Hello, I'm Lindsay Watts, broadcasting live from the 7 newsroom. In just the last 20 minutes, we have learned there is a verdict in the Aurora theater shooting trial. It's going to be read at 4:15 today. Of course, we'll bring that to you live. The courtroom will open up at 4 o'clock. 46 days of testimony, and this jury reached a verdict in less than 2 days. In anticipation of that verdict, we're going to go over some key moments from the trial, and we're going to start with the very last testimony that the jury heard. The expert doctors were key figures during the closing arguments, and we'll show you some of that video now.
As opposed to Reed and Metzner, who focus only on 5 or 6 or 7 individual facts to base their entire decision about sanity on, Dr. Gurr and Dr. Woodcock, to some extent, talk about the psychosis being a fluid and dynamic process that changes over time. And you have to analyze what was going on July 20th in order to figure out whether he was able to distinguish between right or wrong on that date, or whether the psychosis had obscured his ability to do so, whether the psychosis had obscured his ability to deliberate, to act after reflection and judgment. After reflection and judgment. Read that notebook. Tell me what reflection and judgment is shown there. Read that galactic colonization. Tell me about the reflection and judgment shown there. We know that he's been fighting this since he was a kid. Struggling, he says, I have struggled for years and years. I have fought and fought, always defending against predetermination and the fallibility of man. And you know what? Until the psychosis happened to him and overwhelmed him, he won that fight. He was able to suppress these thoughts that came into his mind as unwanted thoughts. Can you imagine being in middle school and having thoughts come into your mind several times a week? Go kill people. You have to kill people. And that continues for year after year after year.
Sustained.
Think about it. Think about how strong and long-standing this mental illness is. The beginning of the delusion, there's no doubt. All of the experts agree. He does poorly in his classes. He continues to go to class. He continues to get okay grades. He continues to turn in his papers. But the fact is, he doesn't succeed in graduate school. The thing that he's wanted to do his entire life and spent his entire life dedicated to, all of a sudden just doesn't matter to him anymore. And what? His classmates come in and say, you know what? Doesn't seem like he cares anymore. He's just not motivated. Well, he's not motivated because he rocked it in high school and rocked it in college, and now he can't rock it in graduate school anymore because it's different. No, he's not rocking it in graduate school because he's mentally ill. And these are symptoms of his mental illness. The social withdrawal, the lack of motivation, the lack of interest in subjects that used to interest you. He's no longer interested because he's overwhelmed by the need to complete his mission. He must complete the mission. The mission has overwhelmed everything else. We could see between the labs that he does well the first semester, the second semester, he does poorly. He writes in the notebook, I attempt to see if I can pass the exams by myself and not by fear. Failure. He fails his prelims. This all happens in the same period of time. You can see that the red is the Gargidata chat and the Hillary Allen floodgates text message on the end. The red are the appointments with Dr. Fenton. The blue are the purchases of the weapons. And the green is him withdrawing from school and failing his prelims. This is all taking place at the same time. It's all interrelated. You can't separate it out. You can't separate him from the situation. You can't separate the mental illness from him. And you can't separate the psychosis from this case and this shooting. Thank you. He changes his hairdo. He hangs the symbols up all over. He does this in his apartment.
As you were thinking about these things, buying a Glock, ordering a tear gas, are you angry, or what's the thought inside you at that time?
Kind of that I had a mission to complete.
He doesn't do this because he wants to gain notoriety, because he wants to be remembered. He denies that to all the experts. He doesn't do it because he's angry, because he's upset about losing his girlfriend or failing out of school. Dr. Reed says those were not important considerations. This is the last communication where he indicates that he's lost the ability to control himself. That's what he says. Calls it dysphoric mania, means it doesn't feel good, but it's mania. And Hillary asks him, can you control it? Is it manageable? And he says, it was. But the floodgates are open now. Now that he's on the sertraline, now that the psychosis has taken over. Love gone, motivation directed to hate, and obsessions which didn't disappear for some reason with the drugs. No consequence, no fear, alone, isolated, no work for distractions. He cuts off all of his contact with his friends. He changes the lights in his apartment to colored lights. He withdraws into his apartment. He sees nobody, virtually nobody, for weeks.
You stopped seeing them at some point, and I'm trying to think of the order of the appointments. You kept every appointment that was made, as I recall.
Yeah.
Okay. But at the last appointment, you communicated in some way that this was going to be the last
This was the
appointment.
last one.
Okay.
Yeah.
And as I recall, even left a little early. This is it. Is that accurate?
Yeah, that's
Okay.
accurate.
Why did you make that your last appointment?
I don't know why.
Doesn't know why. Because the mission had overcome the need for treatment. That's what he said. The mission had overcome. Ladies and gentlemen, at the beginning of this case, I told you that at the end, I was going to ask you to do one thing. And that's what I'm going to ask you to do. Accept the mental illness. Acknowledge the fact that the overwhelming evidence is that Mr. Holmes was in the throes of a psychotic episode when this took place, and that we can't evaluate it based on statements that he made while medicated years later. We can't separate the mental illness from him or from this crime, because the mental illness is the reason, the sole reason, that this crime took place. In your careful consideration of the evidence and Mr. Holmes' future, I would ask you to do good, to be strong. And do the right thing. He's not guilty by reason of insanity. Thank you.
The difference between the experts here is a matter of expertise, effort, and corroboration. Dr. Woodcock made no effort to corroborate anything. That's why he only watched 30 minutes of the Dr. Reed video and reviewed very few records, because remember, he's very busy. Dr. Gurr, same thing. By the time she opined in 2013, she had documented reviewing nothing. But by the time she testified here, she'd reviewed everything. She just hadn't documented it. The issue with cross-examining Dr. Gurr is when someone doesn't document what they've done, or they misdocument quotes, or what's been said, it's hard to cross-examine them on that substance. It's like being in quicksand. So we end up having to talk about all the other issues related to why she didn't do a better job. You can see I'm zipping through here. One of the things that was said right at the end here by right at the end by defense was that this guy had no interest in doing this for any other reason. It had nothing to do with being remembered, and that there was no evidence of that. You will recall from Dr. Reed's interview of the defendant that being remembered was huge for him. In fact, in the notebook, Dr. Reed asks him, "You made a notebook that has to do with how you'd be remembered," and he wrote, "Right." He also, here we go, PowerPoint. Can I get that up there? Everything about this guy is self-centered and self-focused. It has nothing at all to do with any sort of mental illness. Gargi told you that. She said the most important person in the world to the defendant is the defendant. And you know where that sort of subtly showed up? Was in an interview with Dr. Reed where they talked about that Valentine's Day dinner. Do you remember that? And he made the chicken with the crunchy stuff on it and all that, because he liked it. And then he asked him, "Did you do candles?" And he goes, "I did candles." And he said, "Did you do candles because Gargi likes them?" And he said, "No, I did candles because I like them." That theme recurs everywhere. Read the texts. Read the notebook. This guy is absorbed with himself. He's desperate to be remembered, and he's desperate to be wanted. If it can't be by Gargi, he'll try Hillary. If it doesn't work with Hillary, he's flirting with her. No matter what Dr. Gurr says, come on. You don't go twice after the same girl about shorts and talk about how hot she is and not have interest in her. That's not social withdrawal. The selfies. Remember what he tells Dr. Reed? The black contact lenses that just happened to arrive the day of the shooting. And he starts to take these pictures. Dr. Gurr told us the pictures were to show how easy it was for him to accumulate weaponry. Well, we know that's not true. He says they'd look good to whoever viewed them, to Dr. Metzner. Reed asks him, "You took selfies that had to do pretty specifically with how you'd be remembered." "Right. I don't think people are going to remember me for any other reason." It's unusual to have dyed hair like that and contact lenses like that. More likely to remember something unusual than something mundane. I tested it first, wearing it all, put the slings off and on, and I looked at myself in the mirror, and there's the picture he took. It's important to me to be remembered. Is it important for me to be remembered? I'd say yes. And thus the New York Times, from his phone, never ends up doing it, but this is where his head is. Someone needs to see what I've been able to pull off. I put it in the notebook and mailed that, but they got to see these pictures. The last page of the notebook, way down at the bottom, he references the reader, and could this possibly be for Dr. Fenton? classicjimbo.squarespace.com. Now, he never ends up uploading these pictures to it, but this is where his head was when he was thinking about being remembered. And for a guy that wants to be wanted, for a guy that wants to be remembered, for a guy who is willing to kill to increase how he feels about himself, it's paid off for him. Because all that attention that he sought before the murders, it's all coming to him now. This is success. This is his payoff for murdering people. And he knew it was wrong on every single level except the one he cared about the most, and that was himself. But I'm not asking you to remember this. I'm asking you to remember this. On July 19th and 20th, 2012, this guy right here, with hatred in his heart, and it is in everything that he has written before he goes to jail. In fact, he tells Woodcock, I hate everybody. With hatred in his heart and the belief that he would value himself more based on how many people he killed, knowing full well not another person on the planet Earth would buy into this abstract, theoretical, the words he used with Dr. Reed, theory. He armed himself to the teeth over 2.5 months, thought of every contingency, even plotted potentially getting away, went in there and just killed people left and right, and kept pulling the trigger and only stopped when the gun stopped. Thank you. Go back and talk about the things that were raised here. Do it. But when you consider this guy's capacity to know right from wrong, it's not the diagnosis. It's not November 2012. It's not a non-diagnostic MRI from a couple months ago. It's not the expert opinions of two people who are neither forensically trained, nor did they invest the time and effort into getting this thing right. At the end of the day, even without the mental health experts, you know that he knew what he was doing was right and wrong. Not guilty by reason of insanity is saved for people that don't know they're around people, let alone killing people. They're reserved.
Actually, that's a misstatement of the law, Your Honor.
Why don't you rephrase, Mr. Brooklyn? I'll sustain the objection. Rephrase.
Thank you. This is argument, right? When you read those instructions on not guilty by reason of insanity, it's not intended for some nuanced viewing of is it possible that he only thought it was illegal but really believed. That's not what that instruction's about. We know what insanity is based on the words in those instructions. This ain't it. He knew what he was doing when he killed those people. He intended to kill them. That was his specific goal. And when he went in there, and by the way, he didn't have to intend a specific individual. He intended to kill each of them. And when he went in there, didn't care how many he killed, didn't care who he killed. It was just about killing. Grave danger, extreme indifference to the value of human life. This guy gets held accountable. That's what the evidence says. Not because I say it, because that's what the evidence says. And so do two court-appointed, state mental hospital-picked doctors who this is what they do. And they both say the exact same thing. Sane. 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 Guilty. Thank you.
The jury heard during closing arguments. That was on Monday, and here we are just 2 days later, less than 13 hours of deliberations, and we have a verdict that is going to be read at 4:15 this afternoon. What could happen? The shooter could be found not guilty by reason of insanity. In that case, he would be committed to a state mental hospital. He could also be found guilty, and if that happens, the case will move to the sentencing phase. He could get life in prison or the death penalty. This verdict is coming nearly 3 years since the massacre happened at that Aurora theater. 3 years ago, this coming Monday. And next, we are going to listen to testimony from some of the people who survived that day. They are describing the moments that they saw the shooter and realized what was happening.
How would you describe that individual?
The light was dim, so I can't be too direct about the color. It looked like he was wearing a gray outfit. The hair looked a bit reddish orangish, a little bit.
Did it look like a natural hair color to you?
No, it did not.
How would you describe that hair color?
I don't want to, probably a deeper carrot orange, should I say?
What did you observe about that individual sitting in front of you?
He was by himself, and at that time I was speculating what that person could have been doing by themselves, but I didn't read too much into it.
At some point in time, did that person ever move from their seat?
The majority of the time I was sitting there, he was sitting in a seat. When I got a message that my friend had arrived, and I noticed he got up and went towards the emergency exit on the right-hand side of the theater. And I noticed there was a cell phone in the hand, and it seemed, the way his body was positioned, it seemed like he was waiting for somebody to meet with him through the exit door, which I thought was strange. But at that same time, I was walking out to get my friend, so I wasn't paying too much attention to him.
Did you ever hear a phone ring?
No.
Did you ever hear a voice on the other end of the phone?
No.
How would you describe how that person was positioned in the exit door?
In the exit doorway, I know that the exit door was propped open by one foot, his right foot to be exact, and the left foot was on the inside of the building.
Could you see part of that person's body from where you were seated?
I can only see a side profile.
And was it the same person with the orange hair who had been sitting in front of you?
Yes.
And then as soon as because I had turned my head, as soon as I heard it explode, and then right when I went to turn my head forward, I saw a flashing light in the sky, which I thought was or not the sky, in the air, and I thought it was a firework.
Do you know where in the theater the firework thing seemed to come from?
Yeah, it seemed to come from like upper left.
I would give you the pointer, but are you talking about in this area where I'm pointing here or somewhere else? Tell me where.
Well, I guess a little, like more towards the middle front, like, yeah.
And you thought you saw something that was fireworks?
That looked like fireworks to me.
On this wood, I presume it's wood, in front of you, how you heard the sounds coming in front of you?
The shots or the people?
Yes, sir, the shots.
Okay.
Thank you. And how long did it go on like that?
Probably for a few seconds until there was a brief pause.
What'd you do?
I looked for the shooter, and I saw him walking up that passageway. So then I nudged the person that was on the ground to see were they going to move, and they weren't.
They respond to you at all?
No.
Hang on for just one moment, and we'll get back there, okay? You said you see the shooter. And you said it was down by that screen, remember? On
Yes.
the right? Is there something you can point to in this courtroom that is about the distance from where you think you were sitting to where that person was?
I would say that back there by the wall, by that, what's that thermostat?
Oh, yeah, okay. There's a thermostat back here about 4 rows from the back. I don't know what direction that is, Your Honor, but corner of the courtroom. Is that what you're talking about?
Yes.
Tell us what he looked like, or what the shooter looked like to you.
I couldn't see. He was in the dark at the time. The only thing I could see was that he was wearing some type of headgear, but it was definitely dark. So I'm assuming that it was dark colored clothes.
Could you make out any weapons?
Not at the time.
Okay.
When I initially saw him.
That's when you...
So the best of my recollection is that Brandon, Denise, and myself were sitting in this general facility here, as close as we can to the middle of the seats. The figure that I saw was in this general facility here, the flattest part of right next to the entrance and the exits of the theater.
We'll do it one more time, all right, sir?
Yes, sir.
I apologize for this. Sir, would you do that again for us?
So Brandon, Denise, and myself were sitting in this general facility here of the theater seats. And the figure that I saw was in this area here, closest to the exit and to the entrance of the theater.
Thank you. Go ahead and grab it. Can I have that microphone? Because here's what I want to ask you to do. I want you to treat your cane, if you could, like the weapon that you saw that figure holding. If you can, and I don't know if you can move like this, can you show the jury how that figure was patrolling around this area there?
Yes, sir.
Go ahead, sir.
So if my cane is the weapon, I can see him with the gun holstered up to his chest, and he was pointing down to the ground, looking for other people.
Thank you.
But I looked at Craig, and I knew something was really wrong when I looked at Craig.
Why did you know something was really wrong when you looked at Craig?
Because his face was, it was covered in blood, and I could tell that Alex had been hit in the head because of what else was on his face.
And what else was on Craig's face?
It was sorry.
Okay, take a moment.
The flesh of Alex. I don't know how else.
So after you see Craig and you see that, what do you do?
I didn't want to leave. Craig was reaching his hand out to me and telling me to go. And the people behind me were telling me to go too. And I didn't want to leave him there.
So what'd you do?
I told Craig no at first, and he said, no, we have to go. We have to go. And so I grabbed Craig's hand, but I grabbed Alex's hand too. I wanted to take him. I wanted to try and take him with me.
Were you able to take him with you?
No. I had to run out with Craig holding his hand, and I had to drop Alex's hand.
At some point, there was a loud and forceful something that hit nearby. It felt like something hit the seat really, really hard. And I saw Alex slump to the ground. Amanda started screaming his name and shaking him. It was about then that obviously I realized what was going on at that point, that there's gunfire, and I don't know whether consciously or subconsciously I knew that Alex was dead and that we had to get out of there. I grabbed Amanda and said, we need to get out of here, and we ran out.
At first, it was hard to grasp my head around what was going on. And so once people started screaming and getting hit, it became from a surreal situation to a dangerous situation. So it warranted me to get down on the ground and get Rebecca down on the ground as well.
So is that what you did, in fact? Did you get down on the ground, and did you get Rebecca down on the ground?
Yes, okay. I just sure did.
And could you describe for the jury how you got both of you down on the ground?
I just pushed her down and pushed me down too, and we were just sitting right there, and she wasn't moving, but I could see him through the crack of the seat, and the seat was only this big in front of us. And so my main concern at the time was Rebecca, the fact that she wasn't moving, and the safety of others around me. I wasn't really concerned about my own safety.
And Mr. Weaver, you had just demonstrated two things: a crack that was in front of you, and then you also said the seat that was, up above you. Mm-hmm. How approximately long or short would you say that crack was in front of that you were looking out of?
I'll say that crack's about this big right here.
Would you estimate that to be an inch, 2 inch? What do you think?
It's hard to say, but maybe an inch to 2 inches.
And you kept trying to peek through that?
That was the only way I could see the shooter. I looked through there, and then as soon as he started shooting, I would put my head down, and then I would see him for a while, and then it would just get so loud that you would just put your head down and hope that it didn't hit you, but you could hear it hitting objects. You could hear it whizzing by your head. You can hear it, the bullets just, people screaming, people saying, I've been shot, I'm hurt, and just not being able to do anything because you don't really know where the bullets are, coming from or that kind of deal from the shooter.
What are you thinking during this time?
Like I was thinking about Rebecca and her well-being and seeing if she was okay, but she wasn't moving. Just thinking about everybody around me. I mean, people were, at the time were coming down the middle and stepping on my back, and my face is grounded with nasty sludge from the floor, and still looking through the corner of the seat every time the shooter would fire from that corner. And you could see he had some type of helmet on, some type of gear with the flash. And you could see him pretty clearly, but the only thing you couldn't do is see his face.
We stayed crouched on the ground because there was still a lot of gunfire happening. So we just crouched down waiting because we thought that the shooter was going to come row by row and just kill us.
And then what do you remember while you guys were down crouched on the ground after that?
It's a little confusing to put all together just because there was a lot that was happening. I remember that the air was very thick and it was hard to breathe, and that it was hard to stay crouched because I was so pregnant. I was trying not to lay on my stomach. I remember at one point that I saw the shooter walk by our row, and we believe that he went out into the lobby of the theater.
Now, you said you believe that. Did you actually see that, or is that just what you were guessing at the time?
That's what I assumed at the time because I saw I saw him walk by.
Okay, and so when you say by, was that kind of like it rose behind you?
It was like we were laying on the ground, and I guess from my point of view it would have been right here because we were on the edge of that row. So we saw feet. I saw him walk by, and I assumed that he went out into the lobby at that time.
Thanks for staying with us. We're broadcasting live here at 7 News, where just in the last hour, we have learned the jury has reached a verdict in this case. We calculated, and they have been deliberating for about 13 hours, and that's after 11 weeks of testimony. The verdict is going to be read at 4:15, and that is Mountain Standard Time. I know some of you are watching from across the country and even around the world. So 4:15 Mountain Time. The shooter is facing 165 counts, so you can only imagine how long the verdict is going to take to read. I got a question online, which was, what could the outcomes be today, and could the defendant learn his fate? And Andrew, if you could pull up the slide, what could happen? A verdict of not guilty by reason of insanity, in which case the shooter would be committed to a mental hospital. If he is found guilty, the case would move to the sentencing phase, and he could get life in prison or the death penalty. Of course, something we would find out at a later date, not today. This is coming nearly 3 years to the day since 12 died, 70 injured in the Aurora Theater. That anniversary is coming on Monday. Leading up to the verdict, we've been showing you some crucial key moments from the trial. And next, we're going to hear from first responders who showed up at the theater that day, not knowing what to expect. They charged in, doing everything they could to save lives.
One of my trips back into the theater, following a trip outside for triage, someone had brought Veronica Mosier down to the front of the theater from farther up while they were treating other people. She was just inside the door when I walked in. I bent down, felt for a pulse. There was no pulse. The only wound I could see was a wound in the abdomen on the right-hand side. At that point, I saw Sergeant Hawkins, who was an officer at the time, coming down the stairs. I got his attention and said, I want her triaged, I want her out of here. He picked her up and carried her out. He felt for a pulse. Later had mentioned that he thought he felt one, but he hadn't because his own pulse or something to that line. But
even though, when you first saw her, did you feel that she was still alive?
No.
Given that, why did you choose to not leave her in the theater?
Her age. I wasn't keeping a child in my crime scene. you know, if there was any possibility she needed to go. I didn't want my officers stepping over her. I didn't want her at the scene.
My next recollection is Sergeant John's guard motioned me over, and there was a girl about 6 years old on the floor.
Did he ask you to do something with regard to this little girl?
Yes, he lifted up her shirt and showed me where she had been shot once in the abdomen. And I tried to obtain her pulse, and I could not.
Why not?
At that point, my own hands were really tingling and pulsing, I would guess from adrenaline.
Were you asked to do something with regard to her?
Yes, Sergeant John's guard yelled for me to get her and go.
Did you do that?
Yes, I did.
And you picked her up?
I picked her up and I ran out of the front entrance of the theater.
Were there paramedics around?
Yes, yes there were.
Were you aware of whether or not they transported her?
I was aware of the way they looked at me, that she had probably died, and they did transport her to Children's Hospital.
Did you ever learn who that child was?
Yes.
And who was she?
It was a little girl named Veronica Mosier.
After you had taken Veronica Mosier, and she also known as Veronica Mosier Sullivan?
Yes, ma'am.
After you had taken her outside, what did you do?
After I placed her on the pram of the ambulance, I turned around and went back to the theater, at which point I encountered two girls carrying a teenaged black boy who had been shot in the leg. And I said, "Can I help you girls?" And they gave him to me, and I carried him over to where a fire engine was. And I set him with other wounded people next to the fire engine.
When you got your car to the back, was somebody put into your car?
Yes.
Do you recall what kind of injuries that person had?
They were bringing out a female that was shot in the head and I believe in the leg.
Did they put her into your patrol car?
Yeah, I helped open my door, and then I went around the other side to pull her inside. And that's when I remember Officer Williams, I was just telling him I need a holder airway. You just drive. So he got in the seat of my car and drove us to the hospital.
Did you get, where did you get into the car?
In the back with her.
Which hospital did you go to?
We went to University.
Is that the one that's down on Colfax?
Yes.
What was that trip to the hospital like?
It seemed like it took forever. I was just trying to hold her airway. She kept gagging for breaths, and it just took forever.
Did you ever learn who that woman was who was in the backseat of your car?
Yes, it was Jessica Gowie.
When you got to the hospital, what did you do?
There were people there already. They came out and we helped load her onto a stretcher, and then as they took her inside, I just got back with Officer Williams and said, "We need to get back there." So we went back to the theater.
What did you see when you got back to the theater?
It was hard to get back in to the theater. I believe we almost parked at the same spot and walked back into the back side of the theater. There was still a lot of people around.
It was the kind of the thing that nightmares are made of. It was horrible. The flashing lights, the smell of popcorn, the smell of fear and death in the room. It was just a snapshot in time that it was frozen. Is the best way to put it. It was overwhelming when you look at the magnitude of what took place in there.
Now, the deceased were still in the theater.
Yes, they were.
Were they still in the rows or the places where they had died?
Yes, ma'am.
Do you know how many deceased victims were in the theater? Did you ultimately determine that?
Yes, there was a total of 10 deceased in the theater.
Did you see all of them?
Yes, I did.
Did you see any evidence of firearms in the theater?
Yes, ma'am. There was both spent shell casings, meaning that the firearm had been, the round had been shot out of a firearm, both 223 rounds, which were fired from an assault rifle. There was handgun caliber, 40 caliber rounds, which would be fired from a handgun. There was spent or fired shotgun wads and shells that had been fired. There was both magazines located, which are what you use to contain the rounds for the firearms.
I'm going to hand you what's been marked as 2588, and this is not a graphic image. For the record, may I approach, Your Honor?
Yes.
Do you recognize what is depicted in that photograph?
Yes, ma'am. This is a photograph of theater number 9. The point of view would be from the screen side of the theater, with the point of view being the back of the theater itself.
And there appears to be a lot of things at the end of the rows. Do you know what we're seeing in that photograph?
So as there's tons of popcorn all the way down each row, where we had swept through each aisle in an attempt to gather any and all evidence that was available.
And in this photograph, have the deceased been removed from the theater?
Yes, ma'am.
Does this photograph fairly and accurately depict what you observed at some point in the theater after July 20th of 2012?
Yes, ma'am.
Because how many days did you spend in the theater?
5 days.
Your Honor, I'd move for the admittance of People's Exhibit 2588.
Any objection?
No objection.
Do you know what specific day the picture was taken?
I believe it is the 22nd of July.
Okay. So with that clarification, then, the exhibit is admitted without objection and may be published.
And could I publish 2588? Now, there's a pointer behind you, and there's also a wireless mic. And what I would like for you to do is sort of to explain the seating in the theater, if you could.
You'd rather me stand at point?
Sure. And as part of that, did you ultimately number the rows and the seats in the theater?
Yes.
So if you can explain that, and there's a pointer there for you if you'd like to use that.
So it is a stadium-style theater. Rows 1 through 7, I apologize, are from the metal bar forward would be the ground seats. Rows 8 through 20 are the stadium style. We numbered the seats so as if you're reading a book and facing the actual screen. So it would be as if I'm in a seat now. So it would be 1, 2, 3, 4 from your left to your right is the way it was numbered.
So looking at this, if you can show us then where is seat 1 and
This would be seat 1 right here, and this would be seat 20.
in that center section, did you number any of the rows other than that center section from row 8 to row 20?
No, we did not.
And in row 8 to row 20, you number them 1 through 20, just in the same direction you would read left to right?
Yes, ma'am.
And that was all facing the screen?
Yes, ma'am.
So to orient, when we're facing the screen, the right aisle, which aisle would be the right aisle?
So on your right side, right aisle, left aisle, as if you're facing the screen, everything is going to be oriented as if you were watching the movie itself.
Okay, thank you.
And then I decided I needed to get inside that theater right now because people were still coming out and yelling, help, help, help. He's shooting, he's shooting.
How did you enter the theater?
Through the rear exit door, emergency exit door.
As you were going through that emergency exit door, what did you observe?
I could see trails of blood, lots amount of blood, leading up to that back of that door. I then saw AR-type rifle A machine gun type rifle, had the magazine in it, and it was basically the barrel was pointing in a southeast direction. It is laying on the ground there.
Are you familiar with assault rifles?
Yes, I am.
Are you familiar with an M16?
Correct.
Does the AR style rifle look like an M16?
Yes, exactly.
What was the footing like at this area outside of the theater?
I stepped over the rifle to enter that exit door, and I almost fell down. I wasn't sure what happened until I looked down and realized it was the amount of blood that I slipped in and almost fell in. There was so much blood.
Once you got into the theater, what did you see?
There's like a small hallway, and it felt like forever going through that. And I know it's probably only feet. Once I got through to it, it opened up into the theater. On my right was the screen, and on my left was all the seating. There's some, seating above and some other seating, and then you had the floor and the theater to my right, the actual screen. It was absolute. It was horrendous. It was a nightmare.
Overruled?
It looked like a war scene.
No, he's describing what he saw. This is his observation. Overruled. The objection has been overruled, Ms. Brady. Ms. Pearson, ask your next question, please.
What could you hear in the theater?
I could hear some type of alarm going off and cell phones. I remember the cell phones. After seeing what I saw, you could hear cell phones, and I wanted to pick them up and answer them. But I didn't have time, and you can't. But it was hard.
Were you aware of tear gas in the theater?
Yeah, as soon as I entered, my lips, my nose, my eyes started stinging, which is common with tear gas.
Were there people still in the theater, patrons?
Yes, there were several people in the theater, officers, patrons, victims, people who were dead.
What was going on in the theater at that time? What were people doing?
Screaming, yelling, crawling. Other people were trying to help the others that needed more help, trying to get them out of the theater. Officers were trying to help people get out of the theater by carrying, by dragging, by having them crawl.
Do you have any sense of how many officers were in the theater at that time?
I couldn't tell you. 5, 6 that I remember.
Any sense of how many patrons were still in the theater?
I want to say a couple dozen.
What kinds of injuries specifically did you see as you looked around the theater?
Lots of trauma, such as, holes in legs, holes in arms. People were shot in the face and the head. Chunks of flesh and skin were just missing. Some were absolutely unrecognizable. Just a whole variety of different types of injuries.
Did you take action yourself to try to assist the people who were in the theater?
Yes, ma'am.
What did you do?
Going back on my fire paramedic training, I decided to start checking to see if people were alive or who we could, get out of here, who was actually mobile. So I started going around checking pulses and breathing and talking to people.
How did you do that? Did you walk around the theater?
Walked around the theater, assessing bodies that I saw on the ground.
Did you walk up the stairs into the stadium seating?
Yes.
What did you do to try to help the people that you were finding that could be helped?
Some, you would check for a pulse and couldn't find anything. Breathing, couldn't find anything. The ones that you found, I would try and sit up or at least roll on their side so they wouldn't aspirate on their own blood and vomit and whatever else was happening. Some you just knew were dead, and there's no point in checking.
At the point that you had entered the theater, had you seen any fire trucks behind the theater?
No.
Were there any firefighters in the theater?
No.
When you were finding people that could be helped, what did you physically do with them?
So it was so chaotic. I remember checking most ones I checked were dead. I remember, of course, the one that I will always remember is the little girl. I had to step over her because I knew she was gone and continue on, which is absolutely the hardest thing I had to do. But going back on my training, I had to save the ones that I knew I could try and save. So with the absolute knowing that this was far beyond what we're capable of, I exited the theater and I got a hold of Sergeant Redford. I said, we need to start getting these people to the hospital now.
And what did you do?
I went to my patrol car. I emptied it out what I could to make more room for as many people as I could put in there. I got into it. I drove it up to the rear of the exit, and I started loading people into my car.
Who do you recall the kinds of people that you put into your car on this trip?
A couple of them, yes. On the first trip, yes.
How many trips did you ultimately make?
4.
And 4 trips to hospitals?
4 trips to hospitals.
Did you go to more than one hospital during that?
2 separate hospitals.
How many people did you transport?
6.
Some emotional testimony from the emergency responders who were the first to arrive at the Aurora Theater nearly 3 years ago. The anniversary of this shooting is coming on Monday. We're broadcasting live here in the 7 newsroom, awaiting a verdict in the theater shooting trial. That's going to be read at 4:15 today, and that's Mountain Time. So about an hour and a half from now. We know that some of you are watching from outside the state and even outside the country. The jurors have only been deliberating for 2 days. We calculated about 13 hours total deliberations, and that is after an 11-week-long trial. They have 165 counts to decide on, and they could choose guilty or not guilty by reason of insanity. We know that the jurors had some questions in the last 2 days. They asked for a whiteboard, also wanted to know if they could have a guide or some sort of index to help them find different pieces of evidence. These jurors had thousands of pieces of evidence at their disposal to look through, so they wanted a way to more easily find what they were looking for, and the judge said, unfortunately, there wasn't anything like that available, so they would just have to go through the pieces of evidence manually. I want to talk now about the makeup of this jury, and we've created a slide for you here. The people listed in green are the deliberating jurors. The ones in yellow here are alternates, and then the ones in red are the ones who have been excused. There were 5 of them who were excused from the case. We have 9 women and 3 men, and 2 of these jurors have ties to another mass shooting in Colorado, the one at Columbine High School. You can just look at who these people are. We have a little bit of information about them, though obviously no names. The juror in seat 1 is a white woman. She's approximately in her 40s. We know that she is a union plumber and has children in the military. The juror in seat 2, also a white woman. She's middle-aged. She's an attorney, and she said that the death penalty should be rarely used. The juror in seat 3, a woman who's possibly Hispanic and in her 30s. She is a former victim's advocate and says that she believes in fair trial rights. In seat 5, white woman in her 50s. One of the jurors that is linked to Columbine, her niece survived that attack, and she says that she canceled a trip just to serve on this jury. Juror in the 6th seat, a white woman in her 40s to 50s. We know that she was a biology major and says that she believes in an eye for an eye. Down to seat 11 here, a white woman in her 40s to 50s. She's a physicist and also a competitive marksman. In seat 13, a white woman, 50s to 60s. She is a 20-year paramedic and has also treated the mentally ill. Seat 14, this is a white man. He's in his 40s to 50s, and he was living in California at the time of the shooting, so he wasn't in Colorado 3 years ago, nearly 3 years ago when this happened. And in seat 15, a white male. He's in his 30s, a Bed Bath & Beyond store manager. In seat 17, white man in his 30s, Columbine survivor here, and he is currently working for an online business. Seat 21, a Hispanic woman. She's in her 30s to 40s and has said that mental illness is not an excuse. And finally, in seat 23, we have a white woman. She's in her 40s to 50s. She has served on a jury before and says that she will respect her peers. So at this point, we are just waiting to hear what this jury has decided. We know that they, again, had thousands of pieces of evidence to go through. It's a very, very long trial if you have been following with us here online. A key piece of evidence was the shooter's notebook, and he detailed his plans. He spoke about his obsession with killing. He even listed out the pros and cons of different attacks. Again, a very key piece of evidence, and we'll listen now to testimony about that.
Does this notebook, the numbering start at page 1?
No, it does not.
What's the first printed page number?
The first printed page number is 27.
And is that the way that it came to you when you first saw it without pages 1 through 26?
Correct. It remains unchanged.
Looking at the front cover of the notebook, and if I could have People's Exhibit, it would be 341-1 up, please. What does it say on the front cover?
So this has a place where you can write on it. There's a portion for name, and in that is James Holmes. And then there is a line that has the word course, and it says of life. It's been written in there, all in red ink.
In your review of this notebook, and you can take that down, does it contain information about the defendant's plans for the shooting that ultimately occurred at the Century 16 Theater?
It does.
And did he discuss having a desire to kill people?
Yes, he does.
If we could turn to page 35, it should be 341-35. And down on the bottom of the page, on page 35, if you could read for us the last bulleted point.
Yes. It says, the obsession to kill, since I was a kid, with age became more and more realistic. Started as...
And then does it go to page 36?
Correct.
We could have 36 at the top.
Continue.
Yes, please.
The entire world with with nuclear bombs, then shifted to biological agent that destroys the mind. Most recently, serial murder via a cell phone, stun gun, and folding knife in national forests.
Does the notebook reflect that he considered different venues?
It does.
If I could have page 48, please. And just starting at the top of this page and moving down.
So it's titled Case the Place, and then there are 3 bullets, specific bullet marks. Targets, random.
If you could keep reading for us.
The cruel twists of fate are unkind to the misfortunate. Method, colon, bombs, an X, in parentheses, too regulated and suspicious. Biological warfare, there's an X, parentheses, too impatient, requires extensive knowledge, chemicals, and equipment. Serial murder, there's an X, in parentheses, too personal, too much evidence, easily caught, few kills.
If we could move down on that page.
Mass murder / spree.
Judge, at this point, I'm going to object to just the reading of the exhibit. I have no objection to the exhibit being admitted. It's been admitted. The jury it can be published to the jury.
All right, the objections overruled. Go ahead.
Mass murder / spree, checkmark, in parentheses, maximum casualties. Easily performed with firearms, although primitive in nature. No fear of consequences, being caught 99% certain.
And this, he then began to discuss different venues.
Correct. Say bullet mark venue hyphen airport or movie theater. Then it says airport with an X, substantial security. Too much of a terrorist history. Terrorism isn't the message. The message is there is no message. Most fools will misinterpret correlation for causation, namely relationship and work failures as causes. Both were expediting catalysts, not the reason. The causation being my state of mind for the past 15 years.
Does the notebook then actually discuss the individual theaters within the Century 16 in terms of evaluating the pros and cons of choosing each individual theater?
Yes, that's part of the next few pages.
Could I have page 49, please?
So bullet, the movie theater, hyphen Cinemark 16. And there's 3 hyphens underneath. First, isolated. Second, proximal. Third, large. Bullet, what better place to case than that of an inconspicuous entertainment facility, question mark.
If I could have some more of that page up, and so I could see the entire drawing there. Now, if we can stop that there. The drawing that is we see on the left of the screen, do you recognize what that depicts?
I do.
What is that?
This is essentially a hand-drawn aerial of Cinemark 16, the Aurora Mall, Sable Boulevard, and surrounding buildings.
And on the opposite side, does it have an evaluation of the different sides to approach the theater from?
Well, I'm not sure which side you're referencing. On the left side, it says...
On the right side of this photograph.
Okay, right side, there are some bullet marks. South side of theater optimal, 15 screens, and then another diagram of Cinemark itself with some X's and a check mark, reference to the positioning on the building, and then the building is numbered.
If we could go down just a little bit further on this page. Now, do we see, and a little bit more, do we see in this specific theaters numbered with diagrams?
Yes, specifically Theater 1, 10, and 11.
What does he say about Theater 1?
Next to the diagram for Theater 1, various bullets. 1, avoid. Second one, too many exits. Third one, wrong spatial location. And the fourth one, very large.
Theater 10.
Next to Theater 10, he has 3 stars. On the left of the diagram, it says double doors entrance. On the right, primary target, only 2 exits, excellent spatial approach. Most moviegoers take right path, medium size.
And is Theater 11 also noted in this on this page?
It is. It's on the right side of the page. It has 1 star next to 11. Next to the diagram, it says slightly smaller area, 3 exits, good spatial location.
Does the analysis of the different theaters continue on to the next page?
It does.
Could I have page 50, please? If we could have the top half there down to, and does it reference, it looks like the top Theater 12?
Correct. There are 3 theaters referenced in this portion that's visible, 12, 13, and 9.
What does it say about Theater 12?
Theater 12 has 2 stars next to the number 12, and then next to the diagram, only 2 exits, smaller area size, single door entrance, visibility marginal, and then only 1 range.
Or is that ramp?
I'm sorry, ramp, yes.
Theater 13?
Theater 13 is just the number, then a diagram, 4 exits, 2 visible, avoid.
And is there a drawing of Theater 9?
There is, and there's a star, more of an asterisk next to 9, not a star.
What else appears to be drawn on Theater 9?
On Theater 9, you have the exits, the double door exits, and then the exit that's up near where the emergency exit was to go out to the east side of the building where the garbage area is.
And based on having been in Theater 9, is that accurate in terms of where the doors are?
That is accurate. This obviously is just one level, so it doesn't include the upper exit on the top.
And if we could go down to the bottom of the page, after the drawings, some drawings were scratched out, is there another drawing on the bottom of that same page 50?
There is.
And what does that reflect?
It depicts a portion of Cinemark 16, Century 16. It is I guess what would be the southeast corner of the complex, so it includes a couple theaters, exterior doors. Specifically noted on it are theaters 10 and 12. And then there are drawings of vehicles and the indication best parking spots.
Thank you for joining us. We are live here in the 7 newsroom, awaiting a verdict in the Aurora Theater shooting trial. That's going to be coming at 4:15. So that's Mountain Time, about an hour and 25 minutes from now. In the meantime, we are broadcasting some key moments from the 11-week trial. I'm Lindsay Watts, joined by Phil Tenser.
Hi, good afternoon.
You've just been listening to testimony about such a key piece of evidence in this case.
Absolutely key. Something that was so important to the case, Lindsay, and Lindsay and I have both been living in Colorado, working in the journalism business in Colorado since before this shooting occurred in July of 2012. And for 2.5 years or more, almost two and 3/4 years, we knew this notebook existed, but we had never seen it or heard any concrete explanation of what was inside it. And that was, of course, until earlier during the trial, during the segment that we just replayed with Sergeant Matthew Files from Aurora Police. And so we have had now for several weeks since it was revealed in court a copy of this, Lindsay. And I think Andrew is ready to put that up on the screen now so you and I can go through it during this pause as we wait for the verdict itself to be read. You can see it was a computation book. Again, it was packaged and mailed to Dr. Fenton at CU, as you know. Dr. Fenton, the psychiatrist who treated James Holmes 6 times, twice alongside Dr. Feinstein, they all testified earlier during this trial. This is a scanned copy from the court.
And this showed up in Dr. Fenton's mailbox. It had been there prior to the shooting.
Right, it was mailed
only,
prior and found later.
Only discovered a few days after.
Right, I believe it was found on the Monday after, which I guess would be the 23rd of July in 2012. And of course, pages had been torn out and there was all kinds of questions about what that was about, and obviously we don't know, but this is the first page as it appears in the notebook that was put into evidence for those jurors. And it's got that infamous, now that we've seen it, this very strange symbol that, well, everyone has speculated it represents the gunman's idea of what he was going to achieve. And then these two philosophical questions.
What is the meaning of life? What is the meaning of death? Right. And this is the first page of the notebook, along with that symbol.
And here is the inscription to his family. Goober, Chrissy, and Bobo were nicknames for his parents and his sister, and love yas there on that inscription. And now titled, gosh, Lindsay, it certainly seems titled as if it was intended for all of us, or someone else at least, to read. Insight into the Mind of Madness. And here is the basis for this idea of human capital, this doodle of someone, a stick figure on the left without value, and the values of all the people on the right. And then when that scribble occurs, the values somehow transfer. That was at least what the gunman expressed was his belief would happen. Of course, his mental health
Is the heart
of the case, right? Is he legally insane, or is he just mentally ill but still sane under the law? And that's really the core of everything.
Because nobody's arguing that he's clearly mentally ill, so that has been established
By both sides.
By both sides on the case.
And neither side, no one has been advocating for just a plain not guilty verdict. The defense has said over and over again, we stipulate, we admit that this shooting occurred, that he pulled the trigger. Their only thing, and that's why it's called an affirmative defense, we affirm that this happened, but he was insane at the time. That's what the defense has been saying for years now, honestly.
And both sides have used this notebook to make their case on one side or the other.
It's two sides of the same coin, and it's really up to the jury, and only the jury, on how they're going to interpret that. And that's why what you talked about earlier, Lindsay, is so important. The jurors clearly focused on what the doctors had to say. They didn't ask questions about the survivors and what they had to say. They didn't ask questions about wanting to see the weapons or the damage or anything like that. Any of the crime scene photos, they wanted to see the reports from the doctors. But as we continue to go through here, would you keep on scrolling, Lindsay? Because I know folks at home, many of you who have been interested in following with us have seen this. But here we get into the area where he's starting to deliberate what to do.
Ignore the problem, delay the problem, pawn the problem are the three
points here. And of course, one of the assertions throughout the trial was that the gunman had somehow replaced or superseded his suicidal thoughts with homicidal thoughts. And so alternatives to death there certainly does speak toward that point, Lindsay.
And then number 4 here, love and hate.
Right.
And just looking at this, I think you can see, just glancing at this notebook, how on each side they could make their case, because clearly this person is not well. On the other hand, he is making lists, and as we continue to move through this, making plans and deliberating in his own mind different alternatives.
Right. And certainly George Brockler, the district attorney, is saying this notebook is some of the key evidence that he was able to think and function as a member of society. And of course, that is one of the ways to prove or disprove insanity in Colorado law, is that understanding of the morality, the group societal morality of right and wrong. But certainly, even in these pages, and we don't know precisely when they were written, but here on the page that you're looking at, he's talking about diagnosing himself with various kinds of illness, and you'll see midway down the page, schizophrenia is on there, and of course the doctors, the 4 court-admitted experts, there certainly were other doctors who are all very well credentialed, but the 4 court-admitted experts, they all said he was somewhere in that range of schizophrenia.
The self-awareness here is very interesting because he's mapped it all out, the possibilities, and weighing it out on these pages, trying to figure out what's causing what's happening in his own mind.
Exactly. And if you go on to the next page, I believe there's more on this subject, his symptoms now, and you can we can probably breeze through those, but catatonia, fatigue, isolationism, avoiding social interaction, brief periods of immortality, and what does that mean? What does that mean to him is what the jury's asking, but gosh, if you keep on going, he's giving himself all these diagnoses, and some of them, catatonia is one that he ended up being diagnosed with later, but not at this time, at least, not at the time prior to the shooting. At that point, when they said he appeared catatonic, was in the months afterward, after he was jailed.
And an easy argument to make is this kind of self-awareness. When you understand that you have a problem and there's something's wrong,
Right.
seeking treatment instead of going on a shooting spree.
Right.
If you're weighing out the symptoms that you have and you recognize that there's something wrong, you have the choice.
Right, and that was an element of the prosecution's case, and of course, Dan King, the public defender's office, they were on the flip side of that, as you know well, Lindsay, but they were saying that yes, he was exceptionally intelligent, and yes, he was planning and deliberating, but it wasn't for a rational reason. It was because of this irrational sense of this, quote unquote mission. And if you scroll down a few pages here, Lindsay, they do talk, or the gunman writes about the concepts. What's he going to do? And if you keep on going, he talks about this idea, again, a number line. What does that mean? Is that about value? Is it about mind? Interesting and scary questions, perhaps. We're only a few pages away, though, from where he begins. Keep on going. 7 pages, I think, of whys. If he keeps on going, we get to the actual deliberation for the crime itself.
Yeah.
Discussing
Case the place.
Yep, case the place. Reading about, how is he going to do it? What's he considering doing?
And there are the options laid out. He's suggesting bombs and reason why not to go that route, biological warfare. He says serial murder is too personal and too much violence. And then you can see the check mark next to the mass murder spree,
Right.
maximum casualties.
And then he goes on to
performed.
venue, and he considers an airport. And of course, he doesn't like the idea of an airport because it would be associated with terrorism. Of course, we've got, he settles on the Century 16, what was then called the Century 16, near the Aurora Mall. And here, you've got doodles of the map of the area, the theaters themselves, the different theaters he considered carrying out this horrible act in.
15 screens.
And again, it comes down to the prosecution saying this is
Meticulously planned.
meticulously planned, thank you, rationally planned. And the defense saying, well, it may have been logical in the sense of A to B to C steps to take to accomplish a goal, but the goal itself was not rational. And that therein lies the difference. Both sides are saying he was very smart. Both sides are saying he planned very carefully. Both sides are saying he did the shooting itself. Their question is the motivation behind it and whether that was legally sane or legally insane in the state of Colorado.
Right.
Again, we've got considerations for inside the theater,
The
pros and cons, right.
The
individual options, where he might start, considerations of how to secure the doors, looking again at where the police department
was.
in relationship, and also the National Guard, where the National Guard office was, and an estimated response time. And of course, prosecution argues that's why he set the booby traps at his home, at the apartment on 1690 Paris Street. The doctors he met with prior to the shooting, they're listed in here, the psychiatrists and therapists, and his summaries, notes about what they did or did not do for him, if you keep scrolling there. And we're nearing the end of this document here. But at the very last, if you keep scrolling, there are again these questions that are they philosophy, are they philosophical, are they murderous, are they intentional? That's a question that the jury is going to settle for us very soon. I believe there's one more page, and it's something that George Brockler brought up in his closing argument. Right there, scroll back up. There's a page at the very bottom of page 56, Lindsay. There's scribbled in the bottom a web address, a URL. And George Brockler is saying that, alleging that was established so that he could be remembered, or he could post his pictures of himself and be remembered in that way.
Has there been anything on that specific web address?
That address itself, in my experience, has never been active. Certainly George Brockler said that he never did get around to posting those selfies that we saw during the course of the trial. Andrew, I think we've reached the end of the notebook here, and I know that you guys had more planned for what's coming up next, right, as we continue to weight things. Where are we going to next, Lindsay?
So on both sides, really the key witness were these expert doctors,
right,
on each side. And going back to what we were speaking about, nobody is disagreeing that the shooter was not mentally ill. Mm-hmm. The question is, did his mental illness make it so he didn't know right from wrong when he committed the killings?
Right, legal insanity, as it's defined in Colorado law, which doesn't mention schizophrenia, right? It just mentions that right from wrong. So then we've got sound ready from Doctors William Reed and Dr. Raquel Gurr.
One of the things that we heard is that he was willing, and continues to say at the point of the interview, that he was willing back in July 2012 to trade a person's life for that point and to create lots of injuries in other people to get each one of those points. Those are my thoughts about it.
Based on what you've discussed and discovered with the defendant, would it be accurate that he would feel better the more people he killed?
That's the inference. He said, I don't think in this segment, but will in other segments, that he expected to kill some number of people, and that if he killed, I think he said 3, that would make it worthwhile. Glad he killed 12. He kind of voluntarily or semi-voluntarily stopped the killing when he might have gone back in or might have shot someone else, such as a policeman. But at some point he said, it's over, to himself. And there's an implication that there was some relief felt by him when that was over. That is the end of a task. That's assumption on my part. I'm not sure exactly whether that's responsive to you.
When he heads into the theater the night of the 19th, is it your conclusion that he believes he will feel increasingly better the more people he murders?
Objection, leading. Well, he's following up on what the doctor just said, so overruled.
Okay. I'm not sure that he and I talked about his feelings in that regard when he first went into the theater. I think it's reasonable to infer or assume that he believed that each person he killed was going to bring him a point which would make him feel better. That's among the 2 or 3 reasons that he was there.
Look, let me follow up then, because one of the things that he tells you in this segment is that he regrets the people that were injured, the collateral damage, and wishes that the bullets had just simply missed them. Does that match up with your conversation with him about the points he gets from killing people?
It's pretty clear to me that he didn't care, or at least he says that 2 years before we were talking, he didn't care about what he termed collateral damage, that he did what was necessary to get the points. He modifies that somewhat when he talks about if he'd known children were going to be injured. And then, as you notice, we went into the idea, I believe a true idea, that many, many children were injured one way or another. But I think the bottom line is whatever regret he had, and I can't know what was in his heart at any particular time, but whatever regret he had, he makes it clear that getting the points, killing the people, was worth it.
Listen, at one point you ask him, did his ends of wanting to feel better and get these points for killing people, did they justify the means that he used? And he says yes. And my question to you is, doesn't that just automatically mean that he didn't know right from wrong under the context that the court has advised this jury?
No, it doesn't mean to me that he didn't know or was not capable of knowing.
Why not?
If I understand your question
Yes, sir.
correctly.
Yes, sir.
I see two possibilities. One is that there was very little mental illness there that was relevant to the shootings, in which case it seems reasonable to me to look at it as he decided to trade people's lives and all the injuries around it for feeling better. Looked at in a slightly different way, if you think that the thoughts of the points, etc., are a delusion, and then you accept a bit more presence of mental illness at the time, it still says to me that even within some delusion he would feel better. That's not an equitable trade. It's not a trade that he was still aware that he was trading people's lives and injuries in order to feel better. Either way you cut it, that's my view.
In this segment or any other thereafter, did you ever find any, and in fact in discovery, did you find any evidence that this guy says that he was justified and that others would agree he was justified in murdering people?
He says he was justified because he feels better or because he didn't have to kill himself, and he got the points. When I particularly asked him in one of the future segments about whether other people would agree, and asked him in various ways, he said they would agree only if they happen to think the way I do, or something like that. He was clear that this is his way of viewing the world, and it doesn't have to be anybody else's way of viewing the world.
That it wasn't some universal truth he discovered?
No.
Leading.
Sustained.
One thing you did ask him about was whether or not he was being controlled by a master power or some other outside force. First, what's the significance of that?
As I'm looking for significant psychiatric problems, as I'm looking for ways that something psychiatric might be a factor in whether he understands or has the capacity, the ability to know what he's doing and to create a crime. As I'm looking for that, the idea that something's controlling me is a common theme in severely mentally ill people who really can't control their actions or have good reason, not logical reason for you and I, but good reason in their heads to carry it out and are prevented from being capable of creating the elements of the crime. In this case, he continuously denied to me that there was any external force, wasn't God, wasn't Satan, wasn't an external power or something like this. This was him, and it would be an inference on my part to say he was taking responsibility for it, but that's essentially what he said.
Is then the compulsion or the loss of control to do the mission, meaning the mission has to be carried out exactly the way it's planned? Is that part of the psychotic delusion?
Yes. If the mission is not carried out, it's not mission accomplished.
So is that why we have the planning and wait till July 20th before the shooting takes place? Is that why it doesn't happen earlier?
Yes.
Sustained.
Is that or is that not why it happened earlier?
Yes, it is.
Now this hair plucking and this other focusing on schoolwork and video games, now that doesn't make a lot of sense to me. And so maybe you can explain that, because is that something he thought of, like, oh, I'm having unwanted thoughts of homicide and I'm a sophomore in high school, I know what I'll do. I'll pull my hair out, and that will make the thoughts go away. That doesn't make a lot of sense to me.
Overruled. You can answer.
Can you explain that to us?
Yeah, it doesn't happen the way you said it. It's not a deliberate psychosis, is not a deliberate process that somebody brings upon himself or herself and calculates at each step of the way, this is how I'm going to react. The thought comes, it's an intrusive, unwanted thought. I mean, trying to imagine that you're sitting at home, trying to work on your homework, you're not in school, and suddenly the thought, kill yourself. No, kill other, kill yourself, kill other. And he developed his way of coping with it that worked for him. He took it away from him, namely, focus on, do your homework now. And he will notice, when describing it later, that when he was busy doing his homework, the thought will go away. When he was playing computer game, it will go away. When he will pluck his hair, it will go away. And with this, when the thought will come, he was doing what he could do, what within his ability to do, secretively. He will not pluck his hair when other people will look at him. He will do it secretively. He will go to the side and do it, because he did not want other people to see and think that he is crazy. He was checking the different diagnostic. Remember, we are dealing with an individual with high level of intellectual functioning and in the internet available. Somebody was studying biology and wanted to be a neuroscience major. He knew about the brain, and he began to read about it more and more and realized something is really wrong with me. And this is something that he had to hide, and that's not different from other people with schizophrenia. They deny their illness. This is the major difficulty that we have as professionals, not in the criminal setting. It's very similar in the sense that people we see will say, I'd rather die than you tell me that I have schizophrenia. They deny the illness. There's a tremendous stigma and fear of it among people. And the people who develop it notice it. They know I'm losing it. Something I'm different than everybody else. And that's what he was experiencing.
Now, he made a statement to you, did he not, in the course of this first interview, when you asked about a movie. Did you ask him about why a movie theater?
I'm trying to remember if it was in the first interview. What page are you on?
I'm on page 3 of your notes from 12/19/2012.
So you are not in my report, but my written notes?
Yes, ma'am.
Okay. So please, yes. Which page are you on, please?
I'm on page 3.
Yes.
Did he tell you he chose a movie theater because he liked movies?
He liked movies. This was his first response when I asked him, why did you choose a movie theater? And he said, his first response, I liked movies.
Okay, now, you've read Dr. Metzner's, Dr. Reed's report, and is that right?
Yes, I did.
Now, he told these doctors that he chose the movie theater because there's going to be a lot of people there to shoot and kill, and it was a good place to do it. Am I misstating what your understanding of what he told them was?
No, you're not.
Well, how can we explain this inconsistency, or can we?
I think that it was difficult for him in his first interview to tell me the graveness of his actions, and that later on he did mention that the movie theater was part of the proximity to where he lived, and that he was familiar with it, and it was a movie about chaos that appealed to him, why he selected it, but the first reaction was, I like movies and I like computer games, which is quite quite shocking. But I do not see it as inconsistent because the same information that was provided to the other experts was provided to me later.
Okay.
So he did intend to kill people.
And did he tell you that on subsequent interviews when you asked him?
Yes, he did.
And on November 18th, when you interviewed him, November 18th, 2014, did he tell you the movie theater, because it was impersonal, high chance of shooting people, and felt comfortable because it's familiar?
Yes, correct.
Less than an hour now until we hear the verdict in the Aurora Theater shooting trial. Thank you for joining us here on the web. We're broadcasting live from the 7 News studios. I'm Lindsay Watts. The verdict is going to be read at 4:15 Mountain Standard Time. We got a good 3 hours heads up, just because there's so much media attention, obviously, to this case, and more importantly, just so the victims' and survivors' families could be in the courtroom and be ready for this. The trial lasted for 11 weeks, and this jury started their deliberations on Monday. We calculated they've been deliberating for about 13 hours now, so a fairly quick verdict here. At the center of the case is the question, did the shooter know right from wrong when he committed the crimes? Was he legally insane? There's not been any argument as to whether he committed the crimes or whether or not he's mentally ill. Someone was recently asking online, what are the possible outcomes today, and will the defendant learn his fate in the courtroom this afternoon? So we can pull up a slide for you. There are 3 different outcomes, and the first is that the shooter would be found not guilty by reason of insanity, and in that case we know that he would be committed to a mental hospital. If the shooter is found guilty, there are 2 options. The case would move to the sentencing phase, and he could get life in prison or the death penalty. And as we are waiting for this verdict, again, 4:15 this afternoon, we've been showing some important moments from the trial, some key testimony. And what we're going to show you now is something that caught my attention. I was very much anticipating this witness. This woman, her name is Gargi Dada. She was dating the suspect only months before the attack at the Aurora Theater. She offered some interesting insight, and we'll listen now to what jurors heard from her.
What is going on your side of this relationship?
At that point, I was pretty sure I wanted to break up with him, so I was trying to distance myself from him.
Why were you thinking of breaking up with the defendant?
I had been dating him for a few months then, and I still didn't feel extremely connected with him and didn't see a future with him.
Okay, but you don't tell him right away.
No, I was waiting for the best time.
After this G-chat, there's a Valentine's Day. Do you remember that?
Yes.
What did you guys do for Valentine's Day?
He cooked me dinner, and we watched something. Yeah.
32, ma'am. Thank you. This was a little bit less than 2 weeks after that last G-chat and a little bit after Valentine's Day. This is a reference from the defendant that we can read here. What is he referring to, and what, based on your interactions with the defendant, what's going on here?
So his second lab rotation had just ended, and apparently it didn't go well. So he was saying that he won't be joining that lab. He knows that. So.
In fact, right above that, there's a reference. Oh, I'm sorry. Right below that. Sorry, I'm messing you up. I'm sorry, ma'am. He describes the professor's response to his performance, doesn't he, right here on this bottom part?
Yes.
Now, that's February 23rd. Thank you, ma'am. You can take that down. How soon after this do you break up with the defendant?
I don't exactly remember, but probably a few days, within a few days.
And you did it by, you had told us you had either texted him or somehow gotten in touch with him. Did you go over to his house to tell him? And how did he respond to that?
He was calm. He seemed he seemed a bit upset, but he didn't show any extreme reactions. He was calm.
Did he ever show any extreme reactions?
Not that I remember of.
Now, there's a G-chat from March 5th. That's the next one. I don't need to see that, ma'am. But what I want to ask you is, after you break up with the defendant, is there a drop-off in the amount of G-chats and other communication that you have with him?
Yes.
Are you still seeing him in class?
Yes.
Now, how long after you break up with the defendant is it before some kind of relationship starts back up?
Maybe a week or so.
How'd that happen?
I went up to him to ask him if he was doing okay and whether he wanted to be friends.
And?
And we became friends. And
look, and again, I don't want to be indelicate here, but I'm going to use a colloquial phrase here. Friends with benefits? Is that?
Yes.
Okay. And how long did that last?
Until early April.
Okay. Can I get 35, ma'am? This is from March 21st of 2012, and it's just how the defendant signs off to you. Is this pretty consistent, again, with sort of his kind of humor?
Yes.
During those few weeks or even up to a month, and you can take that down, thank you. During that time, was your relationship different than it had been before, and if so, how?
We hung out more, yes, we hung out more in a group versus a lone setting. And I was more distant with him and less romantic with him.
When you spent time together alone, was it at his place, your place, still both?
I think still both. I don't exactly remember.
Okay. 36, ma'am. This is a March 25th, 2012 G-chat. And it appears you reach out to him with this exchange about rickrolling. Tell us what that means.
So, a few years ago, YouTube, the website, played this April Fool's prank on basically everyone who accessed YouTube. Any video you would click on, it would go to Rick Astley's Never Gonna Give You Up. And YouTube coined the term rickrolling for that. So I believe his status, so in Gmail you can have status messages, and his status messages was that video, that Rick Astley is never going to give you up, and that's what I was referencing.
Okay, and then you go on to discuss sleeping and video games. You recall that?
Yes.
And then you get into a discussion where the defendant brings up to you that what he wants to do is evil. Do you recall that?
Yes.
Now, at the time that he references that in the chat, and we'll get to see that, what are you thinking?
Initially, I was thinking he was just messing with me. He was joking.
And then throughout the conversation, does that sense that you have change over time?
Yes, he starts talking about justice. At that point, I start thinking maybe he's serious, but it seemed very philosophical and discussion-wise.
And do you end up over the course of this chat engaging with him in sort of a philosophical back and forth?
Yes.
Now, at some point during this conversation, do you express to him, look, I don't track what you're saying about how this philosophy works?
Yes.
All right. And it goes on here for a few pages that we're going to see. But then, do you recall how this chat ends as you're going back? By the way, do you have any sense that this is imminent or there's a plan in place or anything like that?
No, not at all. This was the first and the only time he had mentioned something like that, and it seemed very philosophical.
Okay. Can we get 39? Yeah. Is this how that chat ends between the two of you?
Yes.
Is that top reference again to the game that you had described to
Yes.
us earlier? And then do you remember if you ended up coming over to play Dom or Dominion?
I don't remember.
Does this ever come up again between the two of you?
So I showed this chat to Ben Garcia because I was a bit concerned, and we decided to go talk to him. I don't remember when we talked to him, but we asked him if he was talking to his therapist about this philosophy, and he said he was.
Okay. And then what I'd like to do, Your Honor, with the court's permission, is then publish the individual copies, give the jury a chance to review it, and then come back and ask some final questions to wrap up sort of the end of this portion of direct. Now, that last chat from March 25th, 2012, you in the past have used a term to describe it as maybe delusional. Is that fair?
Yes.
Is that the psychiatric term or just your term, like a street term, your term?
My term, I'm not an expert.
What do you mean by that?
That it did not make sense to me, and it seemed a bit irrational.
Now, prior to that G-chat on March the 25th, there was St. Patty's Day. Do you recall that?
Yes.
Did you and the defendant and some others go out for St. Patty's Day?
Yes.
Do you remember where you went?
Somewhere downtown. I don't remember the exact places.
Now, you have previously told us that you were sort of special friends during this period of time, but it was after you were romantic. Is that accurate?
Yes.
Was there an incident that took place at the St. Patty's Day get-together?
Yes.
Tell us about it.
So someone came and tried to talk to me, and I found out later that the defendant had gone up to that person and had told the person that I was his girlfriend.
What did you do in response to that information?
I later, outside, not in the bar, confronted him and reminded him that I wasn't his girlfriend at that point.
And when you say him, you're referring to the defendant in the,
Yes.
in the blue shirt over here?
Yes.
Did he have any response for you?
I don't remember what his response was.
Prior to that interaction where you told him that you were not his girlfriend, had he ever expressed to you that he loved you?
Yes.
Tell us about that.
At some point, he said he loved me, and I told him I cared about him as a friend, but I was not in love with him.
Had he told you at any point that you were his first real girlfriend?
No.
Prior to that March 25th G-chat, had the defendant expressed to you how things were going in his third lab rotation?
He had mentioned that his experiments weren't working, and thus it wasn't going well, but he wasn't that long into the rotation.
At some point, did you become aware that the defendant, through the therapist that you had talked about, had been prescribed any medication?
He had mentioned that he was taking some medication.
Do you remember specifically what it was?
No, he didn't tell me.
Now, during the time that you had an opportunity to observe him, did you notice any differences in the defendant?
Not particularly. He seemed to loosen up around people a bit more, but other than that, no.
Did you ever see any big highs or lows or big changes in his demeanor or presentation?
No,
Did his personality change at all?
not that I remember.
Did he ever express to you that he was suicidal?
No,
Did he ever tell you about any past suicide attempts?
no,
Did he ever express to you feeling manic?
manic you meant? No,
Yeah. What, did I not say manic?
I heard Mac, so that's
Oh,
why I asked.
Did he ever tell you he was Mac?
No,
Okay. Did he ever tell you he was manic?
no,
Okay. Did the defendant ever, let me back up. Did you ever reach out to the defendant after you'd broken up that first time, or even the second time, ever, and express to him that you were going through 5 stages of grief?
I don't remember doing that.
Does that sound like you?
That does not sound like me.
Did the defendant ever text to you anything along the lines of the thorn in my side was worth the rose?
No,
Did you ever get a text from the defendant that I don't see the glass, I see around or through the glass, or words to that effect?
I don't remember any such text.
You think you would remember such a day?
I think I would.
Now, you had an opportunity to, you had an opportunity to continue to see the defendant in class throughout this whole period of time?
Yes.
And you know what? I forgot to ask you about one thing in particular. After this March 25th chat, did you sort of still kind of continue to see each other for a bit?
I don't remember the number of interactions we had, but we stopped talking about a week or week and a half after that.
Sometime in April, then, did the defendant contact you with a change in your relationship?
Early April.
Tell us about that.
He contacted me saying that he did not want to be just friends anymore, and I did not want to be anything more than friends at that point, so he did not want to continue talking to me.
Either in that conversation or a future conversation, did the defendant ever reference someone named Hillary?
Yes.
Tell us about that.
He also mentioned that he was hanging out with Hillary at that point, and thus I respected that.
Was that, in your interpretation, was that an effort to explain why he wasn't going to hang out with you anymore?
Yes.
Now, your class that you had that ended in May, do you remember about when in May it ended?
Mid-May, sometime.
Was there a presentation component to that class?
Yes, we had to present we had to choose a topic and do a literature survey of sorts and present something on it.
Is that different than an end of the rotation presentation?
I would say it's lower pressure and not less important, but lower pressure, I would say.
Did you ever, prior to this mid-May presentation, ever see the defendant give any presentation in class?
No.
This was it?
This was it.
Describe for us that presentation, if you recall.
From what I recall, it was extremely awkward. He wasn't good at engaging the audience, and it was extremely awkward.
Is that what made it awkward? The presentation, I guess the manner of presentation?
The presentation style, yes.
Let me ask you, how about the substance?
I don't remember much of the content of the presentation.
Did you have any lasting memories of it being babbling?
No.
Like disjointed or disorganized or?
Not that I remember.
Guys not eating paint chips off the wall or talking crazy, nothing like that?
No.
Objection, Your Honor. It's argumentative.
Overruled.
Did you ever remember seeing any bizarre hand or arm gestures or anything like that?
Not that I remember.
Just seemed awkward.
Just seemed awkward.
Prior to that, by the way, is that the last time you would have seen the defendant in class?
Yes.
Is that the last time you saw him at all?
Yes.
Up until that time, do you ever recall him missing a class?
I don't remember, but he wouldn't have missed a lot of classes, I would say.
Do you ever remember him appearing physically different to you during that time leading up to mid-May?
No.
How about dressing differently?
No.
Behaving differently in class?
No.
Any different hygiene?
Until April, no.
Yeah. When was the last time you think you spoke to him?
We had a conversation early April. I might have said hello in class sometimes.
And did he respond?
I think so.
At the time that he gave that presentation in mid-May, did you ever know the defendant to have owned a cell phone stun gun?
No.
How about a gas mask?
No.
Did you know if he was purchasing a gas mask?
No.
Tear gas?
No.
Weapons?
No.
Do you know how much equipment he had amassed for a future crime?
No, I had no idea.
At any point, did you ever perceive the defendant, in your opinion, to be dangerous?
No.
Can I have a moment, Your Honor?
Yes.
Blank stares, Your Honor. I have nothing further. Thank you.
All right, would counsel approach for just a moment, please?
Thanks for joining us here on 7 News as we get closer to hearing the verdicts in the Aurora Theater shooting trial. I'm Lindsay Watts, and I just got some new information from my colleagues who are right now at the Arapahoe County Courthouse. They're saying that when the judge gets the verdicts, he plans to take about 15 minutes to go through them. So we were initially thinking that we would start hearing the verdicts at 4:15, but now we're thinking it's actually going to be closer to 4:30. That's Mountain Time, and we are still less than an hour away now. 165 counts in this case, so this judge is going to have a huge stack of papers to go through, 3 to 4 pages per count. For each of those, the jury could reach a verdict of guilty or not guilty by reason of insanity. One of my coworkers in the field is estimating it could take an hour and a half to hear every single count in this case. And of course, we're going to be broadcasting that for you here live. We're working right now to get you some reports from my coworkers who are there. We have media locally, outlets from across the country and around the world that are at the courthouse, and we'll take a look now at what they're seeing.
I'm Mark Stewart at the Arapahoe County Courthouse, where in just about 1 hour, 4:15 Mountain Time, the verdict in the theater shooting trial will be read. So far, I've not seen any families show up, but as you can see, there's a lot of media here and a lot of just curious people, really from around the world. This process of reading the verdict will be orderly, but it will also take some time because there are more than 160 individual counts and each one needs to be read. So even though it seems like it'll be a quick process, it will actually take some time, perhaps 45 minutes to an hour. We know family members have been alerted. I have a feeling many will want to talk after. It's kind of the next chapter in their healing, so to speak. Stay with us here on thedenverchannel.com.
I'm here at the Arapahoe County Courthouse where the jury has reached a verdict in the Aurora Theater shooting trial. We know that they are going to read that verdict at 4:15. The judge will read the forms first. That's going to take about 15 minutes. And then it will take an hour and a half to read all 165 counts. And I spoke to some of the theater shooting survivors today, and they said right now they are feeling nervous.
Good afternoon, everyone. I'm 7 News anchor Eric Connor, getting ready to bring you live coverage as the jury has reached a verdict in the Aurora Theater shooting trial. It's the Arapahoe County Courthouse, where that verdict will be read at 4:15, but our live coverage starts on 7 News at 4 o'clock. Take a look at the media circus here. We have media from around the country. The networks are here. We have international media here, bringing their viewers and their readers this verdict. Much anticipated. 11 weeks this trial has gone on, and it took the jury about 12 hours worth of deliberations. Ironically, about 1 hour per victim killed in this horrific crime that happened July 20th of 2012. One of the darkest days in Colorado's history, and we are all over it for you with team coverage starting on 7 News at 4 o'clock. See you then.
Marshall Zellinger outside the Arapahoe County Courthouse, where we're a little more than an hour away from the verdict being read in the Aurora Theater shooting trial. Where I'm standing is where we will bring you all the information from the courthouse. This is where Channel 7's set up right now outside the courthouse in the parking lot. You can see Jacqueline Allen preparing and doing essentially the same thing I'm doing here. Our other media outlets, both national and local, have set up along the parking area here. I'll be going inside the courthouse where at 4:15 the judge will see the information from the jury that they filled out on those 165 pages of forms, 165 counts, 3 or 4 pages each. He'll have to read through them before he even announces the verdict. Reading all of the counts and the verdict given could take an hour and a half, but we'll carry it live on 7 News and on the 7 News app.
As we all prepare and wait for a verdict, we have been showing you some key moments from the 11-week trial. And next, we want to show you testimony about the shooter's booby-trapped apartment. As you might remember, his neighbor called police on a noise complaint, heard music blasting, and she says that she just had a gut feeling not to go inside. Of course, police found a large number of incendiary devices and explosives, and the shooter actually told them about this after he was arrested. Let's listen.
We had gone to bed around 11 o'clock in our living room, and around midnight we were awoken by very loud music, the apartment shaking.
Can you describe the music to us, what kind of music it was?
Like techno or electronic dance music, something along those lines.
Could you hear any kind of vocals?
I didn't make out any vocals.
What could you hear?
I could hear a lot of bass, like the thumping that you hear when a loud car is next to you. And that was about it.
How long did this go on?
It lasted ultimately for about an hour.
Now, you said that you thought it started somewhere around midnight, or?
Yes.
Did you ultimately do something about it or try to do something about it?
Yes, I did. I actually went upstairs. Well, first I exited my apartment and went downstairs to see if the music was coming from downstairs or not. It was so loud it was hard to tell. But when I went up the stairs, I noticed it getting louder, and then I noticed that it was coming from apartment number 10.
So what did you do?
So I knocked on the door, and I told them to shut off the music, but I didn't hear anyone in the apartment. So I thought about opening the door. I had my hand on the doorknob, but it seemed like it was unlocked, and so in my better sense, I went back downstairs and called the police.
Why did you decide not to open the door?
It just seemed really off. I had a bad gut feeling that I didn't want to see what was ever behind that door.
Over dispatcher stay. Hi, I was just calling to report like a noise disturbance in my apartment complex. Okay, what address are you calling from? I'm sorry? What's the address? It's 1690 Paris Street. Okay, that's 1690 Paris Street. Is that North Paris Street, just north of Colfax? Yes. And what apartment is it coming from? It's coming from apartment 10. Okay, so what kind of noise is it? It's just really, really loud music, like the bass. I went on there and tried to knock on their door, and nobody would come to the door, so. What's the name of the apartment? I think it's just Paris Street Apartments. Okay. Did you want contact with the officers, or did you just want to call it in? Well, I don't know if officers are going to be able to get into the building. Okay, so they can contact you if they need to? Yeah, they can. That's fine. What apartment are you in? Number 6. Okay, and what's your name, ma'am? My name's Caitlin. Okay, and what's your last name? Fonzie, F as in Frank, O-N-Z-I. Okay. If the noise stops before the officers get out there, go ahead and give us a call back, but we'll try to get somebody out there as soon as we can, okay? Okay, great. Thank you. Thank you. Bye-bye. Bye.
After you called the police, did the music continue to play?
Yes, it did.
Did it stop during any time soon after you called?
No.
Did you ultimately decide to call the police again?
Yes, I did.
How much after the first call do you think that was?
It could have been anywhere from 30 to 45 minutes.
That time the music was still playing?
Yes.
When you called the police department the second time, the music was still playing?
Yes.
Did anyone from the police department arrive at your apartment?
Prior to me calling
in
them?
relation to your noise complaint call?
No.
How long after you made the second call did the music stop?
I don't remember. It wasn't very long. It wasn't more than 30 minutes to an hour.
The total music, or when it stopped, if it could be a little more clear?
Oh, I'm sorry. It wasn't more than 30 minutes after I made the second call that the music stopped.
How long did the music go on in total?
An hour.
Did you ultimately go back to sleep?
Yes.
Were you awakened later during the night?
Yes.
What happened?
I heard a loud crash, it sounded like it was coming from the back of the apartment complex.
What kind of crash?
It sounded like maybe someone had, I don't know, ran into a wall or something. I later found out that it was the door being kicked down in the back of the apartment complex.
Who came into your apartment building?
I believe it was the SWAT team.
Did they come to your apartment?
They did.
Do you know what time that was?
I don't recall. I want to say it was around 2 o'clock in the morning.
Were you asked to leave your apartment?
Yes, we were.
Did you in fact leave?
Yes, we did.
And I think we can see the thermos a little bit better there. Can you please tell us what we're looking at there?
So again, we have the bomb robot in the door jamb of the defendant's apartment. You can see his front door right here. And again, you see white powder that the defendant has sprinkled on the floor. And then right here is the thermos, and you can't really make out, but the fishing line is attached right to the left of where the door closes.
And if we could have the last one, 5860, please. Tell me what we're looking at there.
Again, you can see the fishing line that's attached to the handle of the thermos. Inside the thermos is a bottle of liquid, and then you can see it's placed on these sneakers at an angle that sits over this frying pan full of a different ingredient.
And thank you, you can take a seat. We can take that down. As a special agent bomb technician, did this cause you concern about whether this was a dangerous situation?
Absolutely.
Excuse me, objection asked and answered.
Overruled.
Absolutely. We were gravely concerned once we saw the booby trap.
The next question is as follows. In your expert opinion, did the room full of devices appear to be set up for show, or did it seem to be assembled to actually ignite / explode / burn? Specifically, you mentioned distractors. Given their presence, is there reason to believe the setup was designed more to intimidate than do harm?
Since that's a very complex question, I'm going to answer that in stages. There are 3 ways to initiate this device. Let's cover the first one, and the fact that the question was asked about, is this to intimidate versus function? Nothing is random in the components that were designed and appropriated for this device. In my case in point, the quick fuse was used to go from the frying pan to the jar to around the room. That was used instead of the hobby fuse because of the speed in which it burns.
May we approach?
That's okay. Don't speculate. And so the last part of the answer is stricken. And that means that you must disregard it, okay? So you can talk about, based on your expertise, what you observed and what conclusions you drew, but you can't speculate. So the last part of the answer is stricken, and the jury will disregard it and treat it as though the jury never heard it. All right, you may proceed.
From my examinations, the data I recovered in my examinations showed that the speed went from the quick fuse, and they didn't use green fuse in that place.
He's talking about his findings. He's not speculating at this point. He's talking about what was used, not the reason why it was or wasn't used or something else wasn't used. Go ahead.
So to answer the part of that question, was this to intimidate versus function? The fact that they used the one instead of the other showed the utility of the quick fuse versus the design of using the green fuse. So that was intentional. It wasn't because you couldn't tell from a robot.
All right, it's sustained. Again, you can't get into whether something was intentional or not. You can talk about what was used. You cannot talk about the reason why it was used or whether it was intentional or not. Does that make sense?
Sure does.
So if you can answer the question based on what was used and what wasn't used, that's okay, but you cannot get into speculating about why something was used or wasn't used, or whether something that was used or wasn't used was intentional or not. Does that distinction make sense?
It does.
All right, and so the jury will disregard the last part of the answer. Go ahead.
From our examination, the one fuse was used, and you could not tell from the robot which type was one from the other from our observations as we're making determinations on how the device is designed. So that eliminates the question and answers the question, was this to intimidate or not? By design, it would have functioned as designed. It would have caused explosions. It would have caused dramatic and aggressive burning based on the nature of the material that was used.
Okay, thank you. The next question, which is the final question, is, as a whole, can you explain, in your expert opinion, what the setup of the devices you examined on site was designed to accomplish? Again, don't speculate about what, don't speculate. You can only talk about based on your expertise and your observations and your analysis. Does that make sense?
It does.
All right.
So the three ways this could have functioned. One was with a frying pan with a hypergolic mixture we discussed earlier in my testimony. If there was a dynamic entry, which would cause the door to open very quickly, the way we're trained as law enforcement.
Outside the scope of the question.
Sustain. Go ahead. Don't go, I sustained it so you can't go down that road. You can only answer based on your expertise in terms of what was used and what wasn't used. The question is, what was the setup designed to accomplish? And so answer it in terms of specifically.
Specifically, thank you, sir. Specifically, the first setup was designed to accomplish within 3 seconds of that fire starting. All 3 of those glass jars should have been fully engaged with an aggressive burn that I described earlier as potentially 4,000 degrees with a thermite material each now being energized. That burning would have taken place, and that's the first side. From that burning, other fuses would have ignited, causing the rest of the material to go, as well as the gas vapors in the room that were contained in the room by the apartment itself. The apartment is acting as another type of container. That's the one way it would function. The second way would have been from that small remote that I described in my testimony that was recovered on the table by the plant. If that remote control was activated, and it's a line-of-sight remote where you point it right at the receiver and you functioned it, it would have caused that electrical current to run down the lines and influence the hobby fuse that it was attached to. The hobby fuse would start to burn, causing the explosions I described earlier. The third way was from the receiver that was rendered safe on top of the refrigerator in the kitchen. This third way, if the receiver received the electronic signal to function, it would be able to fire all of those devices and allow all that hobby fuse to start to burn, and which would, once again, everything was touching itself on all the different fuses. All the devices in that apartment would have functioned had that influence happened with that receiver.
All right, thank you.
I'm Lindsay Watts, live in the 7 newsroom, and we are getting closer by the minute to finally finding out a verdict in this case, or I should say verdicts. There are 165 counts that the shooter is facing. Only about a half an hour away now. Initially, we thought the verdicts were going to be read at 4:15, but we've since found out that the judge will get the verdicts at 4:15 and then plans to take about 15 minutes going through all of the paperwork before he starts speaking. The courtroom, however, is going to be opening up, should be opening up right about now, actually. So people should be starting to file in and take their seats in preparation to hear what this jury has decided. We are going to be hearing these verdicts nearly 3 years to the day since the shooting happened. The 3-year anniversary is this coming Monday. There are 3 outcomes that could come from the verdict today. The jury could find the shooter not guilty by reason of insanity. And if that's the case, we know that he will be going to a state mental hospital. If the jury does find him guilty, 2 different outcomes there, and we won't learn what the case is today. The shooter will be sentenced to life in prison, or he could get the death penalty. I want to talk a little bit about the people who are deciding this case. We'll show you a slide that we've made. The numbers in green are jurors that are deliberating. The yellow, those are alternate jurors, and then the ones in red are the jurors who ended up getting dismissed from the case. There are 5 of those. Jury is primarily made up of white women. In seat 1, we have a woman who's in her 40s. We know that she's a union plumber and has children in the military. In seat 2, also a white woman. She's middle-aged. She is an attorney who said that the death penalty should be rarely used. Seat 3, this woman. Actually, we're going to take you live now into the courtroom.
Good afternoon, everyone. Good afternoon. This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Higgs, and Ms. Spengler. The people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Titch-McGuire, and Mr. Edson. We are outside the presence of the jury. At about 1 o'clock this afternoon, the jury sent a note that reads as follows. The jury has reached a verdict on all charges, and it is signed by the foreperson. I have marked the note as deliberations question number 5 and included the case number and today's date. Before I bring the jury in, I want to address the gallery for just a moment. This is a public trial, and I want everyone to feel welcome and comfortable here. That is important to me. However, you must observe proper courtroom decorum. I am sensitive to the fact that this case may evoke powerful emotions. I fully understand that. For that reason, I have not prohibited emotional reactions. To the contrary, in Order D-79, I recognize that some visible emotional reactions are inevitable and appropriate. What I have prohibited are audible comments and emotional outbursts that may improperly influence the jury. If at any time you feel the onset of an emotional outburst, please quietly and discreetly exit the courtroom. You may return to the courtroom when you're ready to do so in compliance with my order. In general, so far in this trial, there have been no issues from anyone in the gallery. I thank you for that, and I ask that you please continue to conduct yourselves as you've done throughout the trial. Please remember that it is my duty and responsibility to ensure that both parties receive a fair trial and to uphold the dignity of the court. Additionally, I know that there are a lot of members of the media present. You're welcome. I ask that if you're here in the courtroom when I start reading the verdicts, that you please stay until I finish reading the verdicts out of respect for the parties and for the court. All right, with that, are the people ready for me to bring the jury in? Mr. Brockler.
Yes, sir.
Is the defense ready? Ms. Nelson?
Your Honor, before you bring the jury in, I would like to tender a proposed instruction that the court may wish to give the jury in the event of verdicts of guilty.
Well, let's hold off on that until we know what the verdict is. Okay.
Okay.
Let's hold off on that. We don't know what the verdict is. It's premature at this time. Are you ready for the jury, Ms. Nelson or Mr. King? Okay, let's bring the alternate jurors in first, please. The record should reflect that the alternate jurors are now in the courtroom. Looks like you remember your seats. Thanks for your patience. Let's bring the deliberating jurors in now, please. Please be seated, everyone. The record should reflect that the deliberating jurors are now present in the courtroom. Juror number 737, it's my understanding that you're the foreperson of the jury, is that correct?
That's correct.
And it's my understanding that the jury has reached verdicts on all the charges, is that correct?
That's correct.
All right, would you please tender all of the verdict forms with the instructions and any questions that were submitted during deliberations and any answers provided by the court to my bailiff, Ms. Zagel. Thank you. Ms. Gurley, could you please check those? Make sure they're all in there. Thank you. All right, would the defendant please stand for the reading of the verdicts? Verdict form, count 1, murder in the first degree after deliberation. Jonathan Blanc. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. That's part A. Part B is left unmarked. Part C. Did the defendant use or possess and threaten the use of a deadly weapon? Answer, yes. Verdict form, count 2, murder in the first degree after deliberation. Alexander Boyk. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unmarked. And Part C reads, did the defendant use or possess and threaten the use of a deadly weapon? Answer, yes. Verdict form, count 3, murder in the first degree after deliberation. Jesse Childress. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unanswered, and Part C is marked yes in response to the question that I mentioned a couple of times already. Verdict form, count 4, murder in the first degree after deliberation. Gordon Cowden. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unanswered, and Part C is marked yes. Verdict form, count 5, murder in the first degree after deliberation. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unanswered. Part C is answered yes. Verdict form, count 6, murder in the first degree after deliberation. John Larimer. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unanswered. The answer to Part C is yes. Verdict form, count 7, murder in the first degree after deliberation. Matthew McQuinn. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question on Part C is yes. Verdict form, count 8, murder in the first degree after deliberation. Michaela Medic. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unanswered, and the answer to Part C is yes. Verdict form, count 9, murder in the first degree after deliberation. Veronica Mosier Sullivan. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 10, murder in the first degree after deliberation. Alex Sullivan. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 11, murder in the first degree after deliberation. Alexander Teves. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 12, murder in the first degree after deliberation. Rebecca Wingo. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 13, murder in the first degree, extreme indifference. Jonathan Blanc. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 14, murder in the first degree, extreme indifference. Alexander Boyk. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 15, murder in the first degree, extreme indifference. Jesse Childress. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 16, murder in the first degree, extreme indifference. Gordon Cowden. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 17, murder in the first degree, extreme indifference. Jessica Gawi. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered. Part C is answered yes. Verdict form, count 18, murder in the first degree, extreme indifference, John Larimer. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 19, murder in the first degree, extreme indifference, Matthew McQuinn. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 20, murder in the first degree, extreme indifference, Michaela Medic. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 21, murder in the first degree, extreme indifference, Veronica Mosher Sullivan. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is unanswered, and the answer on Part C is yes. Verdict form, count 22, murder in the first degree, extreme indifference, Alex Sullivan. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 23, murder in the first degree, extreme indifference, Alexander Teves. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 24, murder in the first degree, extreme indifference, Rebecca Wingo. We, the jury, find the defendant, James Egan Holmes, guilty of murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Count 25, verdict form, count 25, attempt to commit murder in the first degree after deliberation, Petra Hogan. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 26, attempt to commit murder in the first degree after deliberation, Aiden Avila Arredondo. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 27, attempt to commit murder in the first degree after deliberation, Brandon Axelrod. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered. The answer on Part C is yes. Verdict form, count 28, attempt to commit murder in the first degree after deliberation, Tony Villapando. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 29. Attempt to commit murder in the first degree after deliberation, Christina Blash. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered. The answer on Part C is yes. Verdict form, count 30. Attempt to commit murder in the first degree after deliberation, Maria Carbonell. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 31. Attempt to commit murder in the first degree after deliberation, Alejandra Cardona Lamas. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 32. Attempt to commit murder in the first degree after deliberation, Louis Duran. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 33. Attempt to commit murder in the first degree after deliberation, Craig Enlund. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 34. Attempt to commit murder in the first degree after deliberation, Alex Espinosa. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 35. Attempt to commit murder in the first degree after deliberation, Jacqueline Fry. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 36. Attempt to commit murder in the first degree after deliberation, Joseph Garby. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 37. Attempt to commit murder in the first degree after deliberation, Zachary Golditch. We, the jury, find the defendant James Egan Holmes guilty of the lesser included offense of attempt to commit murder in the second degree. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 38. Attempt to commit murder in the first degree after deliberation, Munery Gravely. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Count 39. Attempt to commit murder in the first degree after deliberation, Eugene Hahn. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 40. Attempt to commit murder in the first degree after deliberation, Kristen K.C. Hahn. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 41. Attempt to commit murder in the first degree after deliberation, Katie Medley. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 42. Attempt to commit murder in the first degree after deliberation, Jasmine Kennedy. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, And the answer on Part C is yes. Verdict form, count 43, attempt to commit murder in the first degree after deliberation, Marcus Kizar. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 44. Attempt to commit murder in the first degree after deliberation, Patricia Legarreta Roars. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 45. Attempt to commit murder in the first degree after deliberation, Brenton Lowak. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 46, attempt to commit murder in the first degree after deliberation, Ryan Lomba. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 47, attempt to commit murder in the first degree after deliberation, Caleb Medley. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered. The answer on Part C is yes. Verdict form, count 48. Attempt to commit murder in the first degree after deliberation, Ashley Mosher. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 49. Attempt to commit murder in the first degree after deliberation, Stefan Motan. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 50. Attempt to commit murder in the first degree after deliberation, Joshua Nolan. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 51. Attempt to commit murder in the first degree after deliberation, Piers O'Farrell. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 52. Attempt to commit murder in the first degree after deliberation, Prodeo Patria. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 53. Attempt to commit murder in the first degree after deliberation, Rita Paulina. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 54. Attempt to commit murder in the first degree after deliberation, Christopher Raposa. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 55. Attempt to commit murder in the first degree after deliberation, Carly Richards. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 56. Attempt to commit murder in the first degree after deliberation, Dion Rosborough. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and The answer on Part C is yes. Verdict form, count 57. Attempt to commit murder in the first degree after deliberation. Carrie Rotman. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 58. Attempt to commit murder in the first degree after deliberation. Lucas Smith. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 59. Attempt to commit murder in the first degree after deliberation. Heather Snyder. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 60. Attempt to commit murder in the first degree after deliberation. Farah Sudani. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to Part C is yes. Verdict form, count 61. Attempt to commit murder in the first degree after deliberation. Catherine Strebe. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to Part C is yes. Verdict form, count 62. Attempt to commit murder in the first degree after deliberation. Jameson Taves. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 63. Attempt to commit murder in the first degree after deliberation. Denise Axelrod. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 64. Attempt to commit murder in the first degree after deliberation. Marcus Weaver. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question on Part C is yes. Verdict form, count 65. Attempt to commit murder in the first degree after deliberation. Michael White. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 66. Attempt to commit murder in the first degree after deliberation. David Williams. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 67. Attempt to commit murder in the first degree after deliberation. Aline Young. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 68. Attempt to commit murder in the first degree after deliberation. Jansen Young. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 69. Attempt to commit murder in the first degree after deliberation. Samantha Yowler. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 70. Attempt to commit murder in the first degree after deliberation. Gage Hankins. We, the jury, find the defendant, James Egan Holmes, guilty of the lesser included offense of attempt to commit murder in the second degree. Part B is left unanswered, and the answer on Part C is yes. Count 71. Attempt to commit murder in the first degree after deliberation, Michaela Hicks. We, the jury, find the defendant, James Egan Holmes, guilty of the lesser included offense of attempt to commit murder in the second degree. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 72. Attempt to commit murder in the first degree after deliberation, Stephen Barton. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 73. Attempt to commit murder in the first degree after deliberation, Nicholas Gallup. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the question in Part C is answered yes. Verdict form, count 74. Attempt to commit murder in the first degree after deliberation, Evan Ferris. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 75. Attempt to commit murder in the first degree after deliberation, Jennifer Avila Arredondo. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to Part C is yes. Or I should say the answer to the question in Part C is yes. Verdict form, count 76. Attempt to commit murder in the first degree after deliberation, Gerald Brooks. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to Part C is yes. Verdict form, count 77. Attempt to commit murder in the first degree after deliberation, Amanda Hernandez Memije. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 78. Attempt to commit murder in the first degree after deliberation, Kelly Lewis. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 79. Attempt to commit murder in the first degree after deliberation, Bonnie Kathleen Portia Zogby. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 80. Attempt to commit murder in the first degree after deliberation, Angiat Mora. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 81. Attempt to commit murder in the first degree after deliberation, Ethan Roars. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 82. Attempt to commit murder in the first degree after deliberation, Nathan Juranek. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 83. Attempt to commit murder in the first degree, extreme indifference, Petra Hogan. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 84, attempt to commit murder in the first degree, extreme indifference, Aiden Avila Arredondo. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 85, attempt to commit murder in the first degree, extreme indifference, Brandon Axelrod. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on to the question in Part C is yes. Verdict form, count 86, attempt to commit murder in the first degree, extreme indifference, Tony Bilapando. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 87, attempt to commit murder in the first degree, extreme indifference, Christina Blash. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 88, attempt to commit murder in the first degree, extreme indifference, Maria Carbonell. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 89, attempt to commit murder in the first degree, extreme indifference, Alejandra Cardona Lamas. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unmarked, and the answer on Part C is yes. Verdict form, count 90, attempt to commit murder in the first degree, extreme indifference, Luis Duran. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 91, attempt to commit murder in the first degree, extreme indifference, Craig Enlund. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 92, attempt to commit murder in the first degree, extreme indifference, Alex Espinosa. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 93, attempt to commit murder in the first degree, extreme indifference, Jacqueline Fry. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 94, attempt to commit murder in the first degree, extreme indifference, Joseph Garby. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 95, attempt to commit murder in the first degree, extreme indifference, Zachary Golditch. We, the jury, find the defendant James Egan Holmes guilty of the lesser included offense of attempt to commit murder in the second degree. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 96, attempt to commit murder in the first degree, extreme indifference, Munery Gravely. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 97. Attempt to commit murder in the first degree extreme indifference. Eugene Hahn. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 98. Attempt to commit murder in the first degree extreme indifference. Kristen K.C. Hahn. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 99. Attempt to commit murder in the first degree extreme indifference. Katie Medley. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 100. Attempt to commit murder in the first degree extreme indifference. Jasmine Kennedy. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Count 101. Verdict form, count 101. Attempt to commit murder in the first degree extreme indifference. Marcus Kizar. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 102. Attempt to commit murder in the first degree extreme indifference. Patricia Legarreta Roars. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 103. Attempt to commit murder in the first degree extreme indifference. Brenton Lowak. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 104. Attempt to commit murder in the first degree extreme indifference. Ryan Lumba. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 105. Attempt to commit murder in the first degree extreme indifference. Caleb Medley. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 106. Attempt to commit murder in the first degree extreme indifference. Ashley Mosher. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 107. Attempt to commit murder in the first degree extreme indifference. Stephen Moton. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 108. Attempt to commit murder in the first degree extreme indifference. Joshua Nolan. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 109. Attempt to commit murder in the first degree extreme indifference. Pierce O'Farrell. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 110. attempt to commit murder in the first degree, extreme indifference, prodeo patria. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 111, attempt to commit murder in the first degree, extreme indifference. Rita Paulina. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 112. Attempt to commit murder in the first degree, extreme indifference, Christopher Raposa. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 113. Attempt to commit murder in the first degree, extreme indifference, Carly Richards. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 114. Attempt to commit murder in the first degree, extreme indifference, Dion Rossborough. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 115. Attempt to commit murder in the first degree, extreme indifference, Carrie Rotman. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 116. Attempt to commit murder in the first degree, extreme indifference, Lucas Smith. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 117. Attempt to commit murder in the first degree, extreme indifference. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 118. Attempt to commit murder in the first degree, extreme indifference, Farah Sudani. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 119. Attempt to commit murder in the first degree, extreme indifference, Catherine Streve. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 120. Attempt to commit murder in the first degree, extreme indifference, Jamison Taves. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 121. Attempt to commit murder in the first degree, extreme indifference, Denise Axelrod. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 122. Attempt to commit murder in the first degree, extreme indifference, Marcus Weaver. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 123. Attempt to commit murder in the first degree, extreme indifference, Michael White. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 124. Attempt to commit murder in the first degree, extreme indifference. David Williams. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 125. Attempt to commit murder in the first degree, extreme indifference. Aline Young. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Count 126, verdict form, count 126, attempt to commit murder in the first degree, extreme indifference, Jansen Young. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Count 127, attempt to commit murder in the first degree, extreme indifference, Samantha Yowler. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form. Count 128. Attempt to commit murder in the first degree, extreme indifference, Gage Hankins. We, the jury, find the defendant James Egan Holmes guilty of the lesser included offense of attempt to commit murder in the second degree. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 129. Attempt to commit murder in the first degree, extreme indifference, Michaela Hicks. We, the jury, find the defendant James Egan Holmes guilty of the lesser included offense of attempt to commit murder in the second degree. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 130. Attempt to commit murder in the first degree, extreme indifference, Stephen Barton. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form. Verdict form, count 131. Attempt to commit murder in the first degree, extreme indifference, Jennifer Avila Arredondo. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 132. Attempt to commit murder in the first degree, extreme indifference, Jarrell Brooks. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 133. Attempt to commit murder in the first degree, extreme indifference, Amanda Hernandez Memije. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 134. Attempt to commit murder in the first degree, extreme indifference, Nathan Juranek. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 135. Attempt to commit murder in the first degree, extreme indifference, Kelly Lewis. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 136. Attempt to commit murder in the first degree, extreme indifference, Angiat Mora. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form. Count 137. Attempt to commit murder in the first degree, extreme indifference, Bonnie Kathleen Portia Zogby. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 138. Attempt to commit murder in the first degree extreme indifference, Ethan Roars. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 139. Attempt to commit murder in the first degree extreme indifference, Nicholas Gallup. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 140. Attempt to commit murder in the first degree extreme indifference, Evan Ferris. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 141. Possession or control of an explosive or incendiary device. We, the jury, find the defendant James Egan Holmes guilty of possession or control of an explosive or incendiary device. Part B is left unanswered, and there's no Part C to this verdict form. Verdict form, count 143. Attempt to commit murder, and for the record, there's no count 142 because that's a sentence enhancer. Verdict form, count 143. Attempt to commit murder in the first degree after deliberation. Corbin dates. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to Part C is yes. Verdict form, count 144. Attempt to commit murder in the first degree extreme indifference, Corbin dates. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 145. Attempt to commit murder in the first degree after deliberation, Lauren Schuler. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 146. Attempt to commit murder in the first degree extreme indifference, Lauren Schuler. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 147. Attempt to commit murder in the first degree after deliberation, Jamie Roars. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 148. Attempt to commit murder in the first degree extreme indifference, Jamie Roars. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 149. Attempt to commit murder in the first degree after deliberation, Evan Morrison. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 150. Attempt to commit murder in the first degree extreme indifference, Evan Morrison. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 151. Attempt to commit murder in the first degree after deliberation, Richelle Hill. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form count 152. Attempt to commit murder in the first degree, extreme indifference, Richelle Hill. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer on Part C is yes. Verdict form. Count 153, attempt to commit murder in the first degree after deliberation, Kaylin Bailey. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer on Part C is yes. Verdict form, count 154. Attempt to commit murder in the first degree, extreme indifference, Kaylin Bailey. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 155. Attempt to commit murder in the first degree after deliberation, Kelly Bowen. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 156, attempt to commit murder in the first degree, extreme indifference, Kelly Bowen. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 157, attempt to commit murder in the first degree after deliberation, Shirley Clark. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 158, attempt to commit murder in the first degree, extreme indifference, Shirley Clark. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 159, attempt to commit murder in the first degree after deliberation, Haley Hensley. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 160, attempt to commit murder in the first degree, extreme indifference, Haley Hensley. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the question in Part C is answered yes. Verdict form, count 161, attempt to commit murder in the first degree after deliberation, Victor Edgar Nava Hernandez. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the answer to the question in Part C is yes. Verdict form, count 162, attempt to commit murder in the first degree, extreme indifference, Victor Edgar Nava Hernandez. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and then the answer to the question in Part C is yes. Verdict form, count 163, attempt to commit murder in the first degree after deliberation, Debra Thomas Kizar. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the question in Part C is answered yes. Verdict form, count 164, attempt to commit murder in the first degree, extreme indifference, Debra Thomas Kizar. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the question in Part C is answered yes. Verdict form, count 165, Attempt to commit murder in the first degree after deliberation, Caitlin Petticord. We, the jury, find the defendant James Egan Holmes guilty of attempt to commit murder in the first degree after deliberation. Part B is left unanswered, and the question in Part C is answered yes. Verdict form, count 166, attempt to commit murder in the first degree, extreme indifference, Caitlin Petticord. We, the jury, find the defendant, James Egan Holmes, guilty of attempt to commit murder in the first degree, extreme indifference. Part B is left unanswered, and the answer to the question in Part C is yes. All right, you may be seated. Would counsel please approach for just a moment? I just need one attorney from each side. Mr. Brockler and Mr. King, thank you. This is a question directed to the foreperson. So juror number 737. It appears that the verdict form for count 2 in part B, it appears that you put an X next to one of the brackets, and then you put a line through it, and then you put your initials next to it. Was that to indicate to us that you had filled it out by mistake?
Yes.
Okay. And so you did not intend to fill it out, is that correct?
That's correct.
Okay, thank you. All right, do the parties want me to poll the jurors? For the prosecution, Mr. Brockler, are you asking that the court poll the jurors at this time?
No, Your Honor.
For the defense, Mr. King?
Yes, Your Honor.
Okay, I will do that. Members of the jury, either party has a right to request that I poll the jurors to make sure that this is each juror's verdict and the jury's verdict. And so I'm going to do that at this time. I'm going to go in order from seat 1 and then up. So seat 1, juror 640. Are these your verdicts and the jury's verdicts? All right. Seat number 2, juror 17. Are these your verdicts and the jury's verdicts? Seat number 3, juror 329. Are these your verdicts and the jury's verdicts? Seat number 5, juror 535. Are these your verdicts and the jury's verdicts? Seat number 6, juror 87. Are these your verdicts and the jury's verdicts? Seat number 11, juror 118. Are these your verdicts and the jury's verdicts? Seat number 13, juror 378. Are these your verdicts and the jury's verdicts? Yes. Seat number 14, juror 155. Are these your verdicts and the jury's verdicts? Yes. Seat number 15, juror 527. Are these your verdicts and the jury's verdicts? Yes, sir. Seat number 17, but sitting temporarily in seat number 18, I don't know how temporary it is. You've been sitting there the whole trial, but sitting in seat 18, juror 737, the foreperson, are these your verdicts and the jury's verdicts? Seat number 21, juror 557, are these your verdicts and the jury's verdicts? Seat number 23, juror 311, are these your verdicts and the jury's verdicts? Is there any other record that you would like me to make at this time, Mr. King?
No, thank you.
And just so that the record is complete, in terms of the verdict forms, let me just once read into the record Part B of each verdict form. And the only one that's a little different is count 141, but the differences are not substantial and are not substantive. But here's how Part B of each verdict form reads. If you find the defendant guilty of a charged offense or a lesser included offense in any count, you should leave Part B of all of the verdict forms blank. If, however, you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case, you should answer the verdict question below. Did you find the defendant not guilty on this count solely based on the defense of insanity? The foreperson should mark in ink yes if the jury unanimously decides that the only element of the charged offense and the lesser included offenses in this count that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act. The foreperson should mark in ink no if the jury unanimously decides the prosecution failed to prove beyond a reasonable doubt any other element of the charged offense and the lesser included offenses in this count. Did you find the defendant not guilty on this count solely based on the defense of insanity? And then there's a bracket that reads yes and a bracket that reads no. Part C of all the verdict forms, with the exception of count 141, which does not have a Part C, reads as follows. If you find the defendant not guilty of the charged offense and the lesser included offenses in this count, you should leave Part C of this verdict form blank. If, however, you find the defendant guilty of the charged offense or of a lesser included offense in this count, you should answer the verdict question below. Did the defendant use or possess and threaten the use of a deadly weapon? The defendant used or possessed and threatened the use of a deadly weapon only if 1. The defendant used or possessed and threatened the use of a deadly weapon, 2. During the commission of the offense proven in this count or in the immediate flight therefrom. The foreperson should mark in ink yes if the jury unanimously decides that the prosecution met its burden of proving beyond a reasonable doubt each of these two conditions. The foreperson should mark in ink no if the jury unanimously decides that the prosecution did not meet its burden of proving beyond a reasonable doubt each of these two conditions. Did the defendant use or possess and threaten the use of a deadly weapon? And then there's a bracket for yes and a bracket for no there in that question or below that question. All right, let me have counsel approach for a moment, please. All right, members of the jury, thank you very much for your patience. I know that I keep telling you that throughout the trial, but I do appreciate your patience. There are times, as you know, when I need to talk to the attorneys about things such as scheduling, and we were trying to figure out, I had a proposal in mind and I wanted to run it by them first, and we're all on the same page or close to it. So here's what I'm gonna do. It's about 5:35 right now, and so I'm gonna go ahead and release you for the evening. Tomorrow is an off day because there are a couple of you who are unavailable to be here tomorrow, and so it's an off day for you. And so you were not planning on being here tomorrow anyway. I'm going to give you Monday and Tuesday of next week off as well. Please understand that we're not just going to be taking time off ourselves. There are things we have to talk about and work we have to do, and so that's what we're going to be doing. I'm going to have you come back on Wednesday morning at the usual time, 8:40. That seems to work pretty well. I want to remind you about the admonishments that I have been giving you throughout the trial. They continue to apply, and I want to make sure that all of you follow those admonishments. We have completed this part of the proceedings, but as you know, given the some of the verdicts, there is another part of the proceedings that we still have to go through. And so it's important that you continue to abide by all my admonishments. It gets a little trickier now because some of you have been deliberating jurors and others of you are alternate jurors. So first of all, those of you who are alternates, you now know that you're an alternate. And there may be a temptation that for you to think, well, why should I pay attention? I'm an alternate. Or why should I take this serious? I'm an alternate. And you need to avoid that temptation. You need to resist that temptation and avoid that type of thinking, that type of attitude, because that's problematic. And I know it takes a lot of self-discipline. I know it wasn't easy for those of you who are alternates to be in a room doing nothing related to the case and not being able to talk about the case and just sort of waiting. I know that's hard, but there is still a chance that we may need one or more of you. You know, in football, they have this phrase about, and I hate to use a football analogy, but, you know, they have this phrase that the backup quarterback is one hit away from being the starter. And the reality is that alternates, all of you, are one excusal away from being a deliberating juror. So you need to continue to take this very seriously, please. And you don't know which of you is next in line in terms of the alternates. The other thing is, you're not allowed to talk to each other about the case. It may be tempting for the alternates to want to learn some things about the deliberations. Please resist that temptation. You cannot do that. You're not allowed to do that. Does everyone understand that? And the deliberating jurors, you cannot talk to the alternate jurors about the case. You cannot, and similarly, you cannot talk to the about the case with each other within each group. So, for example, deliberating jurors, you cannot talk about the case with each other. Alternate jurors, you cannot talk about the case with each other. You cannot discuss the case, you cannot talk about the case with each other or with anyone else. That admonishment continues to apply now. Do you understand that? Just so that you know, we're going to take the evidence out of the deliberations room and we're going to put it back in the storage room. And so when you come back on Wednesday of next week, it won't be there anymore. You've finished the deliberations at this juncture, and so there's no, you should not be going through that evidence or looking at it or anything like that. Remember the admonishment that I have been giving you throughout the trial about not forming any opinions? That admonishment applies now with respect to this next stage, with respect to the potential punishment. That's the next question in the proceedings. And as you know, you'll be asked to determine what punishment to impose. And you'll have two options: life imprisonment without the possibility of parole, or a death sentence. Those are the only two options. You cannot start forming opinions about that, and you cannot start deliberating about that or thinking about that, even internally, privately in your own mind. And you cannot talk to each other about the case or about your juror service or juror experience. Does everyone understand that? All the other admonishments I have been giving you apply in terms of do not consult any outside sources in relation to the case. That includes dictionaries, treatises, the internet, legal books, technical books, religious books, scientific books. You cannot consult any outside sources in relation to the case. You cannot obtain any information about the case from any media reports. There's a lot of media coverage of the trial. You have to be extremely careful right now about making sure that you're not hearing or watching or reading or somehow learning any information from a media report. Does everyone understand that? And everyone's nodding their head yes. You cannot talk to the parties, the attorneys, or any of the witnesses about anything. You cannot talk to any members of the media about anything. You must wear your juror badge at all times when you're on the courthouse grounds so that people know you're a juror in this trial. If you hear that people are talking about the case, remove yourself from that location immediately. And if, despite your best efforts, you inadvertently hear something about the case, let my staff know that you need to talk to me. Does everyone understand that? Yes. All right. Do not permit anyone else to discuss the case with you. I know how difficult this is because when you go home, there may be family members or friends or acquaintances or co-workers, whatever it may be, and they may be curious to want to know what happened or to want to know something about the case, and you cannot talk about the case. You have to stop them. And you have to ask him not to talk to you about the case and not to ask you any questions. The only thing you can tell people is you're on a jury in Arapahoe County, and we anticipate that the trial will be completed no later than sometime in August. That's all you can tell people. All right? Does that make sense to everyone? All right. Let me check my list and see if there's anything else that I want to tell you about. When we reconvene, you will receive additional evidence to consider and instructions on the law that you must follow in making your decision in this next stage of the proceedings. Any decision you make regarding the penalty or the punishment must be reserved until the evidence is completed and you have received the legal instructions that you must follow. And I talked to you before, or actually it was during jury selection, that this next step in the proceedings has up to 3 possible phases, and that you'll be deliberating at the end of phase 1, and then whether we proceed to phase 2 or not depends on what decisions you make at the end of phase 1. If there is a phase 2, then you'll deliberate again, and then whether there is a phase 3 or not depends on your decisions after deliberations at the end of phase 2. And then if there is a phase 3, you will deliberate at the end of phase 3 again, and that's when you'll decide what appropriate punishment or sentence you think should be imposed. But at each point, I'm going to be giving you instructions of law, and at each point, you're going to be hearing evidence and information, and you have to make your decisions following all my instructions of law and based on the evidence and the information presented here in the courtroom. Does everybody understand that? All right. Okay, with that then, folks, I'm going to go ahead and adjourn for the day. At least I'm going to release you for the day. The attorneys and I will talk for a little bit longer, and I'm going to have you come back Wednesday, July 22nd at 8:40. All right? Thank you very much. Get some rest, and I'll see you on Wednesday. Thank you. Please be seated, everyone. The record should reflect that all the jurors have exited the courtroom now. All right. the plan is that we'll take tomorrow off, or at least from being in the courtroom, and that we will reconvene the attorneys and the court on Monday. And so that we can talk about instructions and any other legal issues that we need to discuss before we start. Let's plan to start on Monday at 9, okay, 9 in the morning. On Tuesday, for those of you who weren't at the bench conference, I have granted the defense's request for videotaped deposition testimony for one witness. And so that will take place on Tuesday, and we will start at 8:30 on Tuesday. So plan on that for Tuesday. And then on Wednesday, we'll start, it's my plan that we will start then with phase 1 of the sentencing hearing at the usual time, 8:40 in the morning. All right? Any questions or anything we need to talk about on behalf of the people at this time?
Not about that. I have one other issue, but not about that, Your Honor.
Okay. Anything about that we need to talk about on behalf of the defense, or anything else that you want to say with respect to that?
I will plan on submitting as many proposed penalty instructions as I can for the court tomorrow. Is the court planning on discussing the instructions for all 3 phases on Monday, or how should I plan for that? It occurs to me that we will probably have to have at least one other conversation at some point during the penalty phase.
That occurred to me as well. I at least want to get the introductory comments or instructions finalized, and the instructions for phase 1 finalized, because I think phase 1 will be short based on what the attorneys have represented, and I think it'll go fairly fast. And it's my expectation that we will have the jury deliberating at the end of phase 1 on Wednesday, given what the attorneys have said. So on Wednesday, the jury can deliberate, and then we'll see how we proceed from that. So I want to at least finalize that much, and then maybe talk about a little bit about the other phases in case they happen maybe along the way later on. Does that make sense? Okay, and everybody's saying yes. All right, hold on a second, Mr. Orman. All right, my staff is going to distribute a notice that's notice C214. And also, it occurred to me that you should have copies of all the juror questions and the court's responses. I know you have copies of the juror questions during deliberations, but I don't think you have copies of the final responses that I sent back with my signature on them. So I've asked my staff to make copies for both parties, and so you're going to get that right now. Ms. Gerlings, and I thought that notice C214 had been distributed already. I'm sorry about that, but I'll give you a chance to review it. All right, Mr. Orman, what else do we need to talk about?
Your Honor, and I'm not asking for a resolution of this today, but it occurred to me that we should at least be thinking about how the court is going to want to address sentencing on the counts of attempted murder and the count of the explosive device, because obviously that is separate apart from the penalty phase sentencing hearing the jury is going to be take part in, but there does have to be sentencing for those counts. The counts that are subject to the Victims' Bill of Rights, which are all but one, the victims of those counts will have the right to address the court regarding what they think the sentence should be. And I don't know if the defense is going to want to present any evidence on that. I don't know if the defense is going to want a PSI. I don't know if the court's going to want to try to do this right away or schedule this off at some point in time. But I think we do need to have that discussion. I'd rather not wait until the end of any sentencing trial, simply so that we can start, at least have the victims who are subject to that portion of the sentencing have some idea of what's going to happen. Because right now, if they ask us, we really can't tell them.
Okay. Ms. Brady, do you have a position on that?
Can we discuss that and get back to the court on that part?
Yes. I'll tell you that my preference is not to proceed on that yet. I think it makes sense to have a plan in place, and to the extent that anyone wants to request a PSI, then perhaps you can let me know that now or soon. But I'm not intending to do anything with respect to that until we finalize the sentencing hearing. I think we owe it to the jurors to focus our energy and our attention on the sentencing hearing and go from there.
I can tell the court we're not requesting a PSI.
Okay, are the people requesting a PSI? No. Okay, and I don't need a PSI unless someone thinks that it's required by any of the counts, and I don't believe it is. So unless someone looks it up and finds that it's a requirement, I have plenty of information in this case and more than in any other case ever that I've ever done. So I don't need it. All right, and I suspect that I'll have even more as we go through this next phase or next part of the proceedings. Anything else, Mr. Orman?
No, Your Honor, thank you.
Ms. Brady?
Judge, I was just going to ask the court if we should or can have some witnesses, mitigation witnesses available for Wednesday afternoon. I really believe that perhaps the jury could get past phase one in the morning and we could start with mitigation witnesses if necessary Wednesday afternoon.
If that helps the schedule for your witnesses, I don't have a problem doing that, but that then means that we also have to finalize on Monday whatever introductory remarks I may have for mitigation. And frankly, there may not be any because I'm going to address that at the beginning of the sentencing hearing. But I don't have a problem with that as long as you also understand that we may need to take a day off later on down the line if you run out of witnesses and you still have a witness who needs to testify Monday, August 3rd, for example. And so do the people have any problem with that? Starting with this, or potentially starting with phase two on Wednesday afternoon?
Have a problem with that, Your Honor. I think at some point, and I'm not asking that the defense have this idea today, I would like to just see if we can get an idea of exactly how many days they think it's going to take, because we may or may not want to bring in rebuttal witnesses, and all of those witnesses would be coming in from the eastern part of the country. So we'd have to fly them in and make arrangements, and it's not something we can do, like just have them drive across town.
So yours are flying from the west and theirs are flying from the east.
And
You
we're
can't
meeting in
even
the middle.
agree on that. Yeah. Okay. All right. Well, you should talk to each other. As usual, I'm going to ask that you confer with each other. You folks have been very professional throughout, and you've been communicating with each other well, and I appreciate that. And I'm going to ask that continue so that everybody can make plans. But Ms. Brady, in response to your question, yes, you can have witnesses potentially available on Wednesday afternoon in the event that we're done early by that time with phase one and we're ready to go with phase two.
And I'll check with our witnesses and see if that works out, and I'll let everyone know if it doesn't.
You've mentioned through Ms. Higgs in the past that your witnesses are having some issues in terms of scheduling and that kind of thing. And so I'm going to be as flexible as I possibly can. That's not only for you, that's for the prosecution too, that's for both sides. So I'll work with you. So if it helps you to have some of those witnesses begin on Wednesday afternoon, we'll do that.
Thank
Okay?
you.
All right. Is there anything else on behalf of the prosecution at this time?
No, Your Honor, thank you.
All right, Ms. Brady, is there anything else on behalf of the defense at this time?
No, sir.
All right, and the defendant is being held without bond, correct?
Yes, Your Honor.
Okay, so I don't need to take any action with respect to bond, is that correct?
I think by statute, he has to be held without bail.
Okay, there's no change there. All right, thanks, everyone. I'll see you folks on Monday. Thank you. The court will be in recess.
We are back here live in the 7 newsroom after finding out that the Aurora Theater shooter has been found guilty on all 165 counts. Because he was found guilty instead of not guilty by reason of insanity, this trial is not over, and neither is our commitment to bringing you continued live coverage here online. This next phase of the trial is expected to last several weeks, perhaps up to a month, and the same jury is now going to decide whether the shooter will spend the rest of his life in prison or be sentenced to death. This next phase is going to be the most emotional part of the case. This is where survivors and family of victims will have the chance to explain to the jury how the shootings changed their lives forever. Up until now, it's been about facts, but this is about personal human stories. Family and friends of the shooter will also get a chance to try to convince jurors to spare his life and send him to prison instead of death row. What we've heard is that the jurors are going to be off until Wednesday morning, but the legal teams are going to convene again on Monday morning at 9 o'clock. And so that is when our live coverage will start again. We want to thank you for sticking with us. We hope that you will continue to do so. As someone who lived here in Colorado when this happened, I didn't expect to be so emotional hearing the verdicts today and hearing the names of the individual victims being read. But there are no words to describe what happened here in our state nearly 3 years ago, and we are grateful for justice for the victims and the survivors. If you are watching locally, we know that you're tuned in from across the country and even across the globe, but if you're here in the Denver metro area, we will have live coverage on 7 News starting at 6 o'clock, so just about 10 minutes. You can turn on your TVs. We have a team of reporters there at the courthouse, some great coverage so far. So at 6 o'clock, we will be live on 7 News. Thanks for watching.